Bank permission that we allow me to file vehicle registration matter coming on 30th.
Which case? Don't mention it in the constitution.
Yes.
Lord, before my learned friend start, we know that the documents relating to assent, they have not been furnished to us till today.
Document relating to
Assent of the president.
assent of the president.
Nothing.
It will be with the solicitor general.
The
Make
file
it
side,
available.
my turn is.
Let
turn
us
has not
have a copy. What is so secret about this? Animal rights or no animal rights?
My turn will come.
Available.
Files are here. We'll
Make it available.
Make it available.
anything which is signed by the president can be for public consumption. Like the
But not for public. We are not going to make it public. We are
Your
not going to make it
Lordship's
public.
query was not fully justified. Thereafter, in absence of any challenge to the
I have
assent,
done it.
and now, my lord, yesterday they challenged it at the last minute. Your Lordship, if they are serious, then I'll file my reply. But I don't wish to travel that path unless, my lord, they compel me.
Yeah. You can make it available to us.
Yes.
No,
We are not going to show it to them.
Even we are not going to make it public, my lord. Your lordship,
Let the
rest assured.
Let the matter start. My lord, I am also.
It has already
Your Lordship,
started.
and if, I say something and my lord share it with your Lordship. So there can't be any.
So now who you have concluded.
I am, your lordship just asked me to file an affidavit, so that's what I've done.
That I will consider satisfied.
That's all, Manoj. I just, my
Yes,
learned,
now who's arguing?
my learned friend, Manoj. I may be, Manoj's excused, guys.
Lord, may I argue after his submission?
Whichever way, it's between you. Yes.
I'm appearing in writ petition number 23 and 24. Of 2016,
You're for the,
state of Tamil Nadu. Now, let's see, if I may first touch upon three aspects of interpretation of this Prevention of Cruelty to Animals Act 1960 as amended by the state. Well, the first aspect is pertains to the query which my Lord Justice Ravi Kumar had put in the very beginning, my Lord, and in my understanding, my Lord, has not been answered. And that is, my Lord, how do we construe the expression unusual pain or suffering?
unnecessary.
Unnecessary. I'm sorry, unnecessary pain or suffering, which runs through various provisions of the Act, including the preamble. Preamble, section 3, section 11, both 1 and subsection 3, all of them will not use this expression repeatedly. The first aspect is not that unnecessary pain or suffering. The word unnecessary will qualify both pain or suffering. So unnecessary pain or unnecessary suffering. That's how this expression, Muller.
Yeah.
I have asked on my written note, Muller, this is covered there. But I'll be referring, Muller, mostly with regard to culture when I come to it. So if coming back to the Act, Lord, unnecessary pain or unnecessary suffering, that's how, Lord, it should be looked at. It unnecessary qualifies both. The second is, Lord, the second aspect of this is that when it says unnecessary pain, the infliction of unnecessary pain or unnecessary suffering is to be prevented. It posits, Lord, that there is some necessary pain or suffering which is going to result on account of the activities which are permitted by the Act. For example, Lord, it says 11(1)A, Lord shall recollect, says overloading is. Now, it doesn't mean that when you load, then there is no pain or suffering. But since the activity of loading the transport load is permitted, the rules specify how much weight can be carried, how many people can be carried. So if you are compliant with the rules, which are regulatory rules, and are limiting yourself to that, the pain is there, the suffering is there, but that is necessary not because that activity is permissible. Likewise, overdriving or overrides. So driving and riding are both permitted. And they will not, as the Lord Justice Joseph said, but they don't enjoy this whether somebody is riding, they are made to. So that pain is the necessary pain because the activity is permitted. In short, what I'm driving at is that the expression unnecessary pain or suffering has to be construed in relation to the activity permitted. What is necessary and what is unnecessary pain.
How does the act proceed? Does it proceed on the basis that some human person is owner of the animal,
Yes,
and in course of ownership, that human person's activities are regulated
yes.
to an extent? Is that the legal philosophy behind the act? About
that
ownership
also.
of the animal by
Yes,
a human person, or animals are taken as a independent entity?
no, as in relation to the human being,
Yeah.
the entire act is prevention of cruelty by whom? By the human beings. The entry has been put in entry 17 very carefully. It's negatively put, prevention. So the legislature will decide, my lords, while legislating under entry 17, what is cruelty they can define, how much pain or suffering can be made permissible and what will be unnecessary. It's all within the domain. This argument, my lord, that you are perpetuating the entry is prevention. But while exercising power in that field, the legislature will have to decide what is the definition of cruelty.
Any person, if
Yes.
any person, the
Yes.
person can only be a human being.
Yes,
If the section 11, if any person beats, so it can only be by a human being.
that's it.
As to whether that understanding a person will continue in Article 21 and all that is a different issue.
Yeah, that's right. Now, in fact, if
That's a criminal act also.
yes,
So that there must be, when you do this, there has to be a sort of mens rea, sort of mental framework that you are doing it deliberately. You are so, lacking in compassion
that's right.
that you do this.
And even the definition of 2A animal is in relation to human being. Animal was not a human.
11A also suggests
The
mens
same.
rea, because
Obliged.
kicks, there is that mens
Hits
rea
if
is
somebody is kicking.
overrides,
somebody else, a human being.
overloads, all those torches everywhere.
That's right. The very entry 17, my lord, indicates that it is in relation to human being because somebody is being prevented from doing the cruelty. Most laws used to be anthropocentric, my lord. So therefore now with this ethics of compassion, which the human beings have realized on account of the environment, on account of it being a sentient being, or on account of, my lords, the fact that
There
we have to
cannot-
live with them.
Cannot be any doubt with respect to that, because
Yes.
see also,
Yes.
any person willfully or unreasonably administrates,
Yes.
there is no question of an animal administering another animal.
Yes,
It's only the human being.
gratefulness. So therefore, it's in relation with human being, and there are activities which are permissible and which are regulated, and there are activities which are prohibited. There are activities which are totally kept out on account of some justifiable consideration about which the legislature has made value judgment. So unnecessary pain has to be construed in relation to the various clauses which by themselves or by the exemption clause grant liberty to the human being to do that act. Now, kindly see A11A for a second, Wallace. Beats, kicks, overrides, overdrives, overloads, tortures, or otherwise treats any animal so as to subject it to unnecessary pain. So now this last phrase runs through all the expressions. It's not that if the farmer while driving his bull to the farm to his farm for tilling, if he gives a kick by himself, that will draw the Criminalization Act provision. So as to cause unnecessary pain or suffering. This is very significant aspect of this act, not because this per se pain and suffering aspect. There are acts, permitted acts, which cause some pain or suffering per se. So that per se aspect, once exempted or once allowed, they stand overridden, or rather becomes permissible to that extent.
So that if you look at it from the perspective of essential human activities
Yes.
and non-essential human activities. For example, if you need the animal, do you domesticate the animal with that purpose only? So man has always needed animals and the rest of the environment. They
Yes.
are necessary.
Yes.
So when it comes to sporting events, entertainment,
I'll come to
that is
sporting.
the area.
I'm conscious of Lordship's queries, my lords. The question is, my lords, if I may answer, my lord, in brief here itself. The legislature is entitled to exempt activities on some justifiable reason. Now that justifiable reason could be based on religion, could be based on safety considerations, could be based on experimentation for curing diseases, etc. So there are variety of factors which can, for example, killing for food. Now the food culture comes in. One can't imagine, if we ban fish, then where goes the machi jhol, So every state in India, has got subcultures. It's a multicultural country. So somewhere, you need biryani, somewhere machi jhol, somewhere, that mean, in the banana which is cooked in Kerala,
That's right.
So idea is that food, when it says, that clause says you can kill for food any animal. That is culture. It's not unavoidable thing. It's not something without which we cannot exist. If we pitch it at that level, everybody can survive. After all, the vegetarians and the vegans, they are surviving. So it's not that if we don't eat fish or we don't eat the muttons, etc., then we will die. It's not that. It's only the culture, the food habit, the choice. So large number of people are eating this. Now, how do you prevent straight away say that, sorry, banned? Now the Muslims might say that our religion says that you will have halal. So 28 comes in. Extreme suffering. Not only killing, but killing in a manner. Because this 11.3, when it talks of killing, please have a look at this, very interesting, Lord. 11.1L. Oh, I'm sorry. Which is the food one? Yes, 11.3E. 11.3E. Commission or omission of any act in the course of the destruction or the preparation for destruction of animal as food for mankind, unless such destruction or preparation was accompanied by infliction of unnecessary pain. So even when you are killing, don't do it in a manner, so stun the buffalo, then kill. Don't kill it in front of any another buffalo. These are some minor changes. I don't know whether it really makes a difference to the buffalo mullets, whether it's killed in front of another or not. But as they say, sentient being mullets understands the pain of the other fellow buffaloes, if I may use this expression. So it says, unless such destruction has. Now look at this, mullets. Even with regard to killing, the expression unnecessary pain or suffering is occurring. So since killing is permitted, all right, kill. That much pain and suffering is, we will tolerate. But while doing so, please ensure that either anesthesia is given or they are stunned or some. But had this been only E, then halal would not have been possible. So comes 28. Now here is the religious basis for this extreme pain justification. Nothing contained in this act, the whole act is overridden for extreme pain.
Yes.
Shall render it an offense to kill any animal in a manner required by the religion of any community. So then religion, what is a value which the legislature keeps in view in order to even permit extreme pain.
So, yeah, argument can be that in all A to E deals with aspects either relating to the safety of the human being, like for example, destruction of stray dogs, for example, then extermination, then research for the real benefit of the human being, and E, which is food, which is considered to be
Now-
virtually essential.
So it's not all safety, food is essential, but because of the food culture.
For example, you go to the hill area,
Yes,
as I discovered when I went to Nainital,
yes.
I found that contrary to the practice in Kerala, where the Brahmins don't eat meat, I was in for something like a rude shock, and I found many of my colleagues
Yes, in the hill areas.
helping. So they eat it. So the culture is because the weather. You go to the Arctic, for example. Can you survive on vegetarian food? Maybe you can. There are people who.
Those who are vegetarian, they
course they
remain
are.
vegetarian when they go abroad.
But the conditions are so, the protein you need.
So that's how culture is born. So over a course of year, people living in a particular environment,
Correct.
necessity of environment or habit. Because when we are born, if our family is eating, generally the
Without meat
progeny
also, without meat, one can survive. I am a living example.
Yes. Yes.
Man or human being started as non-meat eater.
Yes, they were hunters. So we
They-
are all hunters actually.
That's right.
You
Then
read,
food gathering, then agriculture. But so things have evolved. Many have continued. So now we have more variety, more choices. And therefore, the food habits, the food culture is. So this is entirely food culture. So culture is definitely a basis, not on the basis of which an exemption can be granted.
Your taste buds actually dictate.
Yes.
You see, when you find cooked non-vegetarian food on the plate, on the table, it is your taste buds which sends a signal to your brain.
That's right.
You're used to a particular taste. That makes you comfortable. Euphoria in your brain.
So not from taste neutral when we are born, we move on to some acquiring of taste.
That's right.
And the point is which I'm making. Now, the point I'm making is that it is for the legislature to decide which value judgment to attach weight and respect. Once they decide that on account of religion, we will tolerate extreme pain, that's a value judgment. Nobody can. Lord, we all know even religion has evolved and should evolve. We can't keep on saying that age-old practices, Lord, all some of them, Lord, initially may have been good, but today, Lord, from our understanding, are evil. So religion also must evolve. But is it a stage where we have reached where we can say that 28 needs to be deleted? It's for the legislature to decide, Lord, but we have reached that stage or not. A whole complex life is to be considered for that purpose. There is so much meat industry is there, employment is there, and so it's a huge complex.
Very correct. The question avoidable, whether it is avoidable alone cannot decide this.
Yes,
Because vegetarian survives, and
Yes,
therefore
right.
that cannot be a reason one can say in the strict sense. That means even without meat you can survive.
that's right.
But that cannot be.
So this essential, non-essential, avoidable, unavoidable, but this classification, my Lord, which was made in the previous judgment is completely erroneous. That doesn't, my Lord, come out from this. And
Are you arguing that yes, there can be categorization, but the legislature must do it?
that's precisely my submission, my Lord. It is for the legislature to pick up a value, make a value judgment with regard to a particular activity, look at the people's, my Lord, habits, the people's culture, their lifestyle, the pattern of living. That is culture. And you take note of all those things and then make a value judgment. Is it the right time, my Lord, now to do it away, eliminate it, or to allow it? Allow it, then in what manner to allow it? All this is prevention of cruelty. Every cruelty cannot be abolished straight away.
But this value judgment theory, it is bound to change with a flux of time,
Yes.
with understanding.
Of course, Manoj.
So therefore,
But the-
it can never be static.
No, it's certainly, I totally agree, Lord. Everything evolves. I'm myself saying even religion must evolve. But the point is, Lord, can in exercise of judicial review, the court, Lord, with all these imponderables, complex factors, is it possible at all, my lords, to put it on a balance?
So in a way, you are saying when Nagaraja was pronounced, the value judgments that prevailed at that point of time may have been all right, but with better understanding. But what is the change? You must tell us.
No, I'm not saying that when Nagaraj was delivered, it was all right. I'm saying Nagaraj was wrong in drawing this distinction of.
You are saying it's wrong.
Yes, avoidable, unavoidable, essential, unessential, and getting into that fact itself, Lord, in exercise of judicial review.
You are arguing in effect that animals do not have per se an independent enforceable right. Whatever, it's actually a regime of restriction which the legislature imposes on human beings.
Keeping in mind the constitutional mandates, on one side the human rights, on the other side the duty of compassion, they have to be, Lord, balanced, keeping the human rights superior, Lord. That is how it is. And otherwise, this Prevention of Corruption Act itself cannot, Lord, be sustained then. If you say kill and extreme kill because of religion, what is it? Because we human beings subscribe to a religion and we have chosen to subscribe, which mandates that you have to kill in this manner. So 28 comes in. Now Nagaraj says that this is ecocentric. I don't see how this PCA, the Prevention of Corruption Act, is
Cruelty to animals act.
Cruelty Act.
Why you are saying about corruption?
Nagaraj says that this is ecocentric, whereas the state amendment of 2009.
So you are referring to prevention of corruption, that is.
Yes, Prevention of Corruption Act made by the central government, parliament. Nagaraj said that this is ecocentric, whereas state act.
Cruelty to animals act.
You are talking about corruption. You said corruption.
That is why.
Sorry.
That is
Prevention
why-
of Cruelty Act is ecocentric, whereas the state act. Let me use Central Act and State Act.
So it's better to say PCA Act.
Yes,
PCA.
PCA.
To avoid the other.
That's right. So PC Act, my Lord, is ecocentric, whereas State Act is anthropocentric. Now, how do we characterize, my Lord, this PC Act as ecocentric? My Lord? the whole 11.3, 14, 17, which it says for military training, etc., 28, all of them are anthropocentric. This whole act is anthropocentric, but it tries to balance in its own way.
The balancing.
It tries to balance in its own way the duty of compassion. Whether we will not extract this duty of compassion from the animal being sentient or the environment, compassion or human dignity, the fact that we are living with animals, they are our resource. So from whichever way we derive, Lord, what comes out is not the right, but a duty of compassion. And unlike these foreign judgments, we don't need to go around, Lord, and pitch our sense of duty, Lord, on dignity and environment, etc. Because we have Article 51A, Lord, which requires balancing. So we don't need to go other countries, Lord, where they did not have. For example, Lord, in that monkey case, Ecuador, they drew it from the nature. Because we are all part of nature, and therefore, Lord, from there they drew this duty. They recognize the animal right, but they say it is not equal to human right. It is subservient to human right. So ultimately, Lord, you may call it right, but it becomes subservient to human right. So is whichever way we look at it, there is an element of balancing which the parliament and the state legislature has to do. And when it does that balancing and permits some act, then the pain and suffering which is inevitable, incidental, or per se involved in that, that becomes exempted. The cruel aspects remain. Now coming to the second aspect, Lord, I hope not I have made myself clear on this unnecessary pain or suffering, Lord.
That's right.
In fact, if your Lordship will look at 11.1D, 11.1D, conveys or carries whether in or upon any vehicle or not in any such manner or position as to subject it to unnecessary pain or suffering. So when you carry it on a vehicle, my Lord, you have to chain it. Some pain or suffering is inevitable.
What about 11B? Last time also we asked you. 11B. Please read 11B.
Employs in any work or labor for any purpose any animal which by reason of its age or disease, infirmity, wound, sore or other case is unfit to be employed.
What you'd like to highlight is employees just jump over to for any purpose and or other cause unfit to be so employed. Permit?
Yes.
Now here if you just use for any purpose.
Other cause, my Lord, will have to be read ejusdem generis, my Lord.
So other cause is when the bull is naturally not, suited for, that's what this is Radhakrishnan discusses.
No, that in my humble submission, my Lord, look at
other cause.
Lord, ejusdem generis has to draw, the bird will have to draw the color from the preceding birds. The birds of feather flock together, my Lord.
Or other cause is very wide.
Other cause is wide, but every time when the words are otherwise, or for other causes, then, my Lord, one has to look at the previous words, namely disease, infirmity, wound, sore, something, my Lord, which is the body itself is suffering because of ailment. Age, disease, infirmity, wound, sore. Look at the collection of words.
That depends on your, dynamics of your interpretation. You want to place a dynamic interpretation suited to welfare of the animals. You could say, like, when it's afflicted with gross fear. That is the whole, see, ultimately.
Now, let me take the subsequent expression.
Yeah.
Because of other cause is unfit to be so employed.
Unfit.
So before employment, he is already suffering from, not after employment. It says, for other cause is unfit to be so employed.
That's right.
So pre-employment,
That's right.
if he is suffering, so I can't pick up a diseased animal and not.
Because it means from your previous experience, you have watched how the animal reacts. when there are cheering crowd, whichever way you put it, and of all that they did in Nagaraja, which you have removed now, but still the substratum of fear remains. That you let loose the animal.
But
You
that's
know
where-
the animal is surrounded by
that's-
about 14 men.
I understand, my lords, but that's where I'm submitting, my lord, that once the legislature exempts,
The value difference.
then the pain and fear element, my lord, which is inevitable and inherent, that is what the exemption is taking care of. The per se pain, the inevitable pain and fear, or the incidental pain or suffering on account of the activity, that is what is taken care alone. I'm emphasizing the word alone, my lord, so that the cruelty, extra cruelty aspects, my lord, are eliminated.
That is the reason you have a veterinary doctor
Yes,
and you take the fitness.
yes.
And only after the fitness,
Is cleared, then.
then only is permitted
Yes,
to cut.
that's it. I'm grateful.
That is the subsection 3.
Yes.
But then what will the veterinary doctor certify about what the bull is going to experience?
No,
So then it will fall under necessary.
fit because of
Yes.
otherwise, that is.
That's my humble
The
submission.
animal is fit.
That's how this unnecessary word, we have to attach some.
See, there is a thing called post-traumatic stress syndrome. It is one of the well-recognized psychiatric disorders. Supposing you had gone through a harrowing experience in life, human beings,
Yes.
there is even the hint of a resemblance of a repeat happening, going to happen. It can trigger that stress syndrome. In London, in fact, a person committed murder and then he set up this defense. He said that immediately I went back to that experience. I thought it's going to come, and therefore I did it. The stress.
So, my lord, my submission still remains the same, my lord, with respect, my lord, that stress, that pain, that fear, which is inevitable, incidental, Lord, on account of the activity which has been permitted by the legislature in its wisdom and decriminalized it. That's also very vital, Lord, 28A, which my learned friends were emphasizing all the time, Lord. 28A, it is no more Jallikattu, conducting Jallikattu is no more an offense. Now it is the legislature's domain, Lord, to criminalize or not to criminalize. 28A is a standalone provision. Nothing can compel the legislature, Lord, to criminalize it, to make an offense. Even if other provisions are ignored, Lord, there is no offense now. That is standalone. Now, may I come, Lord, with this to 11.3? How do we look at this non-obstante? And this is in the context of my Lord's query about 11.1 being overridden, my Lords. And that if my submission, my Lord, founds it comments to your Lordship, Lord, then that will take care of 254.2 also.
Do you have a
Sorry.
standalone copy of the Tamil Nadu amendment?
Yes, it is annexed, Lord. It is.
No, annexed to.
He just wants a slim copy.
Yes.
Each time we don't have to go through.
Okay, all right.
That is cruelty to the gentleman.
That is why this expression is used as standalone.
Necessary pain.
Standalone.
That's unnecessary pain. Can be avoided. Each time we go through it, where is it? Everybody.
Alex,
To everybody.
get it. Get a printout of it.
Avoidable. Avoidable.
Other clauses using this expression, I'm not dealing with it. In my submission, I have dealt with all those clauses. Now, please come to 11.3 minutes straight away. Please see this. Nothing in this section shall apply to these expressions. I am taking this the first expression, dehorning of capital. Dehorning of cattle. Does it mean, my lords, that while I am taking my cattle for dehorning, I can keep on brutalizing by kicking?
Obviously,
Not.
In the Doberman breed, there's a detailing of the particular breed also.
Now look at castration.
Just one. Yes.
Now look at castration, my lord. If I'm taking my cattle, my lord, for castration, can I go on, my lord, beating, kicking, overriding? No.
No.
Likewise, branding, my lords. Nose roping. Now, much was said about nose roping by petitioners also, and nose roping is permitted by Parliament itself. In the manner prescribed.
That's right.
Now, when I'm nose roping, I'm not entitled to keep on kicking. But the point I'm making is that the non-obstante clause is limited to the activity permitted, and it does not totally override 11(1).
Yeah.
So 11(1), the very fact that Jallikattu is included as F does not entitle anybody to beat, kick, override, torture. Once this interpretation is accepted, my lord, then things fall in place. The Act itself is not regulating. The Central Act provides by 11(1) what is not to be done. And notwithstanding is only permitting that which is expressly mentioned and nothing more.
Yeah.
Now, there is a judgment of your lordships where your lordships have explained how to read, my lord, a non-obstante clause. 2009 4 SCC 94.
Chakravarti.
4 SCC 94.
Central Bank.
Swami decision.
I'm drawing your lordship's attention to paragraph 98 onwards, that is at page 130. If I may just mention, my lord, what was the issue in this case was that the state of Kerala had in its Sales Tax Act made a provision that the recovery of debt will be the first charge. Now then came the Recovery of Debt Act and the Sarfazi Act, Lord, then the issue was raised by the bank that my debts are over the state's debt, and that was the controversy. And they relied upon the non-obstante provision to say that everything in the State Act goes. Now, 98 to 101, my lord, just they prescribed the normal principle well known to your lordship, about textual, contextual, purposive, and all that. Then kindly come to 103, page 132. A non-obstante clause is generally incorporated in a statute to give overriding effect to a particular section of the statute as a whole. Your lordships have this provision. My Lord Justice Joseph has 103, page 132.
Page 1, okay, para 1.
103.
Yes, yes.
A non-obstante clause is generally incorporated in a statute to give overriding effect to a particular section of the statute as a whole. While interpreting non-obstante clause, the court is required to find out the extent to which the legislature intended to do so, and the context in which the non-obstante clause is used. This rule of interpretation has been applied in several decisions. Then State Bank of West Bengal versus Union of India, the court must ascertain the intention of the legislature by directing its attention not merely to the clauses to be construed, but to the entire statute. It must compare the clause with the other parts of the law and the setting in which the clause to be interpreted occurs. In Madhav Rao, Chief Justice Hidayatullah Observe that the non-obstante clause is no doubt a very potent clause intended to exclude every consideration arising from other provisions of the same statute or other statute. But for that reason alone, we must determine the scope of that provision strictly.
Yes.
When the section containing the said clause does not refer to any particular provisions which it intends to override, but refers to the provisions of the statute generally, it is not permissible to hold that it excludes the whole act and stands all alone by itself.
Yeah.
A search has therefore to be made with a view to determining which provision answers the description and which does not. In R.S. Raghunath, a three-judge bench referred to earlier judgments in so and so, and then court's para 11 is extracted. The non-obstante clause is appended to a provision with a view to give the enacting part of the provision an overriding effect in case of a conflict. But the non-obstante clause need not necessarily and always be coextensive with the operative part so as to have the effect of cutting down the clear terms of an enactment. And if the words of an enactment are clear and are capable of a clear interpretation on a plain and grammatical construction of the words, the non-obstante clause cannot cut down the construction and restrict the scope of its operation. In such cases, the non-obstante clause has to be read as clarifying the whole position and must be understood to have been incorporated in the enactment by the legislature by way of abundant caution and not by way of limiting the ambit and scope of the special rules. In Varadarajulu versus State of Tamil Nadu, then the extracted portion, it is well settled that while dealing with a non-obstante clause under the legislature wants to give overriding effect to a section, the court must try to find out the extent to which the legislature had intended to give one provision overriding effect over another provision. Such intention of the legislature in this behalf is to be gathered from the enacting part of the section. In Ashwini Kumar Ghosh, the enacting part of a statute must, where it is clear, be taken to control the non-obstante clause where both cannot be read harmoniously. The DRT Act and the securitizations were enacted by Parliament in the backdrop of recommendations made by so and so. Then kindly have notes. The next page.
Yes.
However, 111. However, what is most significant to be noted is that there is no provision in either of these enactments by which the first charge has been created in favor of banks, financial institutions, or secured creditors who are the property of the borrower. Under Section 13(1), the Securitization Act, limited primacy has been given to the right of the secured creditor to enforce security interests vis-a-vis Section 69 or 69A of the Transfer of Property Act. In terms of that subsection, a secured creditor can enforce security interests without intervention of court or tribunal, and if the borrower has created so on. So the point is not that we have to first read the main clauses and see what is it that is permitted. Only to that extent 11(1) is overridden. The whole of 11(1)A will not go.
Yes.
So what is essential, necessary for conducting Jallikattu, that alone will remain. The clause of Tamil Nadu now says Jallikattu, which is conducted in accordance with the culture and taking care of the well-being. Our rules elaborate on 11(1)A. We provide for what will be the contours of the arena, what will be the runway, the bull run area, the collection point. Before the veterinary experts are there, they will look into it. So all that has been prescribed. So the rule is adding upon what is there in 11(1)A. This beating, kicking, overriding, overloading, torture, etc., which treats animal, that part is not overridden. So therefore, biting of tail and use of chili, drugs, etc., cannot be given because C is there, 11(1)C.
Yes.
So these three aspects with regard to the Act, I wish to point out, my lords.
Yes.
And if I am right, my lord, then on this, then what follows from this is that when our Act was sent to the President under 254(2), Now the act itself is showing not that we want to insert exemptions not in these provisions. The bill is very clear. And the bill is seeking to insert that exemption in the PC Act. So the president is fully aware not that at what point there is a contradiction and what exemption is being sought and where it is being inserted in the PC Act. It is not at all necessary, my lord, at that stage that the rule should have been done. What is the rule doing? The rule is not either reiterating what 11(1)(a) is there, or, my lord, it is expanding on this prescription about the space. Giving of water, ensuring water is given 60 square feet for each animal. So all those things are additional. So whether that rule is added upon or subtracted upon, ultimately 11(1) was clearly there as a protection. Preventing unnecessary pain or suffering.
See, the Prevention Act of 1960, it repeats with the 1890 Act.
Yes.
Now, the 1890 Act is essentially, you will find, it's almost the same. But a committee went into certain inadequacies.
Like the board was formed,
So,
which
you
was
have-
not there.
You have a report of that committee. Have you gone through the committee? What is it that led to the amendments?
In the SOR, my lord,
This is 1890 Act.
the statement of object is there in the beginning, my lord, that mentions to some extent.
That's right. No, it's essentially the same,
We'll get, yes,
except that a very treating animals cruelly is a title, section 11.
yes,
The earlier section was penalty, but ultimately it is a penal provision.
yes,
Intended to create an offense. That Salmond, when he said that when somebody in interpreting the laws in England, which virtually are reflected in India, you create a duty, and if you violate the duty, it leads to an offense. That doesn't mean that a right is created.
yes,
The distinction between, because it is for the purpose of defining an offense, that the section sets out what constitutes offense. Creating the offense by itself doesn't create a right in favor of the animal. And Salmon goes on to say that in the eastern countries, like we are, they have rights for idols, and that specific rights are created in favor of idols. We
as
have
those rights were created as long custom.
long.
Yes,
But in law, jurisprudentially, there can possibly be no obstacle in creating rights for animals, is what Salmon says.
so certainly not, by statute, certain rights have been given that, namely, one right is that unnecessary pain or suffering should not be there.
No, but it's not a right. See, the point is, it's not a right. You have to understand.
That comes out as a
It is
duty.
It is a duty on the
Yes.
human being,
That's right.
which
I
if you
stand-
violate
yes.
leads to him being punishable. That is different from a right.
But if an act dealing with the animals not wishes to create a right, statutory right, it can.
It can.
But these are not for the thing for the legislature to decide, my lord,
That's right.
whether we have reached a stage where we need to
Because
give that right.
What you're saying is that it repealed the 1890 Act. So apart from certain changes which were brought about, for example, the 1890 Act was applicable only in the municipal areas.
Yes.
It did.
Now this applies wider area.
Animal was defined differently, captured, etc., etc. Now it has expanded the meaning of the word animal.
Yes.
So there have been improvements, but the essential substratum remained the same.
Same.
The only change that is brought about is with the onset of the Constitution. Compassion, Article 21, whether it's attracted and things like that.
Even that compassion comes much late, my lord, not in the
That's
beginning,
right.
my lord. But so it's evolving, my lord. The best thing is that shows that legislatures are aware and they're trying to do their utmost and balance, my lords. It's a complex balancing exercise. Now, having said that, my lords, the next aspect, my lord, I've already pointed out section 28 about that criminalization aspect, my lords, because 28 is a standalone provision. Once it is decriminalized, it would not be permissible to strike it down to say, my lord, that it will criminalization will remain. There can be regulations without criminalization. So 28A is standalone, and nothing has been pointed out, not independently, to say that it is manifestly arbitrary. Now, my lord, coming to the aspect of competence, my lord, Mr. Venugopal submitted about 17 that you are providing for perpetuation and not prevention.
Yes. Yeah.
Now, my lords, 17, when it says prevention of cruelty to animals, my submission is that while legislating under this head, in this field, both parliament and state legislatures are entitled A, to define what is cruelty, B, to decide which cruelty is to be prohibited,
Yeah.
and C, which aspects of cruelty are those which are merely to be regulated, and which of them have to be left untouched, like section 28. So therefore, it can't be said that if the parliament, I am taking the original act, if the parliament decides not to regulate a particular activity which is covered by 28, then it cannot be said that the parliament is perpetuating cruelty. It is just that that cruelty is based on religion and parliament doesn't want to regulate it. So this entry 17, when it talks of prevention, it is necessarily implicit that the legislature will have all this power, panoply of powers. This field is not a limited field that every time, for example, supposing Parliament had not made Prevention of Cruelty Act at all. So all these cruelties would have continued.
Can they come to section 428 and 429 of the Indian Penal Code?
Yes.
428 and 429 of the Indian Penal Code.
.28.
428, 429.
Those things like.
Whoever commits, may I please it?
Yeah.
Whoever commits mischief by killing, poisoning, maiming, rendering useless any animals of the value of 10 rupees or upwards shall be punished with imprisonment. Either description for a term which may extend to 2 years or with fine or with both. Then 429 says, whoever commits mischief by killing, poisoning, maiming or rendering useless any elephant, camel, horse, mule, buffalo, bull, cow or ox, whatever be the value thereof, or any other animal of the value of 50 rupees or upward shall be punished. So these provisions remain.
You know, what you wanted to bring to your notice was, if you come to section 11 of the Cruelty Act,
Yes, Manoj.
it's an 1960 Act, it's after the Penal Code. If you come to 11L,
Yes.
now it speaks about
Mutilates any animal or kills any animal,
by
including
using
stray
the harm
dogs,
or any other
injections.
unnecessarily cruel manner. What we are concerned with is, he shall be punishable in the case of a first offense with fine not to exceed 10 rupees.
Yes.
So if he does it for the first time, if you have the choice of applying section 428 or 429, under the, ironically, the act which is supposed to take care of animals, it visits him with 10 rupees.
10 rupees.
And there you can punish him for 5 years. So which will survive actually, whether after the enactment of this 1960, both are by the central government, both by the central parliament.
No, both will survive, because the first part of L talks of the use of method of strychnine injections
Or any other manner.
or in any other manner. So that widens.
So any other cruel manner. So if you look at the irony of it, if you do it in a very cruel manner, you will be punished with a lighter sentence. Whereas if you kill in the manner provided in the section 429, it can go up to 5 years.
Yes.
I mean, we find it a little.
But that is based on mischief, who commits mischief and thereby causes.
So, I mean, it's somebody else's property. So basically,
Yes.
animals have always been regarded as chattels and properties
Yes.
in England.
Yes.
Continue to be so.
That's right. That contradiction is there.
Yes.
Here. So the 428 and 429, it doesn't gel well with, the scheme of the act. Because it can be anybody else's. Mischievous, if you do it with your own animal, perhaps it is not mischief.
And this was inserted in 82. L.
That's it. And they were even more, clear about it, because animal was basically treated as having value,
Yes.
as a
that's
chattel, as a thing, as they
Yes.
call it in England. It's called a thing. Now the movement is to not call it a thing. It's an insult to call it a thing. It is a sentient being, as you rightly pointed out.
But we use these expressions, but ultimately the market
Ultimately, you
treats
call
them
it a
as
thing.
property.
Ultimately, you call it a thing. in your
Market
mind.
treats them as thing and property. No, that's how they are
Just wanted to point.
bought and sold and
Livestock.
slaughtered, and meat is sold. So all
Here it
through.
is 10 rupees. Then you will get away. So depending on, you can be charged under this section or that section.
Does it also the kind of way the same kind of offences are being treated, difference of legislative value also? It is the same legislation which is
May I proceed, Lord?
Where is the confusion? Both will sustain. No
Yes.
overlapping, nothing, yes. Any offense if committed under the IPC, in addition to what is the offense is punishable under the act, will you have to face the consequence. Where is
Both,
the-
there can be a charge under both.
Yes, if you commit any kind of offense under the IPC, you have to be equally punished.
And all
Okay,
those
sir.
questions will arise, Lord, even when somebody questions, Lord, that which, because of Article 20, which one, Lord, will be. For our present purposes, Lord,
Yeah.
So I was on entry 17 minutes of the constitution,
Correct.
and my respectful submission was not that this entry does not take away the power of the parliament or the legislature to prescribe for exemptions and regulations. And it is for the legislature to decide which cruelty is to be prevented, which is to be regulated, and which is allowed to remain as such, as in case of section 28.
What do you say to the two judgments he relied on? He relied on two judgments.
That was not the case of tax, not where under the mines and mineral, not where they said that you can charge a particular tax or royalty,
That's right.
on the mining in the land, but it was all that judgment has been referred to 9 judges now, my lord. Finally, much of that judgment, my lord, based on synthetic chemicals itself. Synthetic chemicals stands much diluted, my lord. The first onslaught came in 91 itself, when sale tax part which was dealt was, my lord, declared to be per incurium. And then, my lord, in Bihar Distilleries case, Justice Jeevan Reddy, my lord, declared that this, so far as it dealing with license of potable liquor, that is not covered by synthetics. So that judgment, my lord, itself is much eroded. The judgment my learned friend referred will all be considered by a 9 judges judgment now, because synthetics is referred.
That's right. That's right.
So therefore, my lord, there being a land or being a space, my lord, which is being taxed, because even if you dug up the land, my lord, what remains is still land, my lord. That's. But we don't need to go into tax aspects and all that. That was a different entry. And I'm putting a question, supposing Parliament had not made the act at all, my lords, then whatever was going on would have gone on.
Then possibly 428, 429.
Yes, 428 would have applied. In fact, Jallikattu has been going on till 2014 until this Nagaraj judgment came. Before Nagaraj, no, it is the central government which came out with a notification saying that bull is not a performing animal. And that was the cause for the judgment.
Actually, 428, 429 proceeds on the basis of the offence of mischief under 425, which deals with whoever with intent to cause or knowing that is likely to cause wrongful loss or damage to the public or to any person causes the destruction of any property. So this is a throwback to the bygone era where animals have been treated as property. This is a sort of reflection of that sentiment that you had.
Yes.
That they were property. You cause destruction of somebody's property section, so both offences can be pressed.
Can be pressed. So, Lord, that question will arise as and when, Lord, the charge is pressed, Lord, and both charges are there. Somebody may.
We are just saying that sentiment was just property in 1890. That
Now, what is the tax treatment for accounting purpose? Somebody is owning a prize-winning horse. Is it reflected in the balance sheet as an asset or a property?
house,
Will have to.
big house,
Any chartered accountant
what is accepted as change.
among us?
So therefore, Lord, entry. The law is, Lord, that entries have to be construed liberally, widely. They are field of legislation.
Yes.
So it is for Parliament and legislature to decide, my lord, which one to control, prohibit, regulate. So the different, my lord, methodologies are available to deal with this issue.
Then will it not make it open, expose it to the charge that it is manifestly arbitrary? You make a law under entry 17. It is not an essential activity for the human beings. It is entertainment for them at any rate. Culture, we call it. And you subject the animal to cruelty in an entry which relates.
If culture is a fundamental right under Article 29(1), why cannot it be made a basis, my lord, of justifying an exemption based on 29(1) if that activity has been going on for a very long time? In a particular season, without, my lord, variation. Since ages. And we have set out in our counter affidavit, and there is a research also done by Jawaharlal Nehru University, my lord, which all indicates that this is very old, my lord. And there are rock paintings available, my lord, where this depicting, my lord, this is going on. And even Justice Radhakrishnan doesn't say that it's not culture. He says culture in the form in which it is being done, it's not. So he's merely pained at the cruelties which were being practiced. And that led to this. Certainly, we have to make all out
What is
efforts.
the material for culture which you have?
Yes, I'm coming straight, my lord, to that. But right now, 17, my lord, is very wide. And incidentally, I may also point out entry 33. My learned friend pointed out entry 15. Kindly see entry 33, list 2. Even if we take it as a sport or entertainment.
Yeah.
Possibly treated as assets.
There are sports which are not pure and simple sports like the cricket which we have. Around the year it goes on in different forms. And there are sports, my lord, which are meant for rural people, my lord, who can't have polo ride, my lord, on the horse and who cannot. So they want a cart race.
Entertainment.
Yes, and sports and entertainment. But it has an aspect of prevention of cruelty. Therefore, Lord 17 also gets attracted. Now, a word about 254(2) further, my lords. As I said that the Principal Act 11(1) survives, so that was there. The assent was properly given. No necessity at all for the rules being submitted. But more than that, my lord, in this judgment which my learned friends relied, that is Kaisar-e-Hind. Lord, if your lordship recollect, in Kaisar-e-Hind, what happened was there was a rent control act made by Maharashtra. Now it was conflicting with
Citation.
2002 volume 8 SCC 182, which is at serial number 20 of petitioner's compilation. So the issue here was that the State Act was conflicting with more than one central enactments. And the assent of the president had been sought only with respect to one of them. So this court said that we will not go, the validity of the assent cannot be tested. That's beyond judicial review. But we can see the coverage.
Malad, we are a little confused because Mr. Dwivedi keeps referring to a counter affidavit. We are in the first matter. My learned friends are in some of the other matters. We have never received a counter affidavit of any kind.
So many articles which they are giving to us across the board here.
No, that's
Now we are on a constitutional matter, not on a large matter. Now
the difficulty, my lords, is this.
My learned friend should have taken the counter affidavit. He has been raising this objection. He could have asked and we would have given.
No. Is there a counter affidavit is the question. I just asked. I was told there's a written submission. And we have never been served with a counter. My learned friend can't say there is material to establish culture without a counter affidavit. And there is a finding of fact in Nagaraj that it is not a case of culture. No material is there. So I'm not clear on how my learned friend is arguing this entire point.
I'm sorry you never asked me. I would have given you.
No.
In writ petition number 24, it is there. A common counter was filed.
Who is
number
put in 24?
24.
We don't have such a counter.
Having is something which you
No,
would
but you
ask me, I would have
served us.
given you over a dinner.
No, we asked on previous hearings, mentioned
Not
specifically,
this,
there's no counter.
Not
And we were told there is some vague document, but nobody ever gave us a
Mr.
document.
Venugopal, why you have this controversy? Take the counter now and go through it.
Please hand over a copy of the counter. We've not had a chance to controvert it, Malutz, by filing a rejoinder also.
Mr. Grover filed an application for 254, but we are not objecting, we are producing file and all, but all right, have it now.
You give me a. Hello.
Kindly have paragraph 25.
Yeah.
So kindly have para 20 minutes. I'm sorry, para 20.
20 and
It is true that President's assent as notified. In the Act, nowhere mentions that assent was obtained qua repugnancy between the state legislation and specified certain laws or laws of parliament. But from this, it also cannot be inferred that as the president has given assent, all earlier laws or laws on the subject would not prevail in the state. As discussed above, before grant of the assent, consideration of the reasons for having such law is necessary, and the consideration would mean consideration of the proposal made by the state for the law enacted despite it being repugnant to the earlier law made by parliament on the same subject. If the proposal made by the state is limited qua the repugnancy of state law and law or laws specified in the said proposal, then it cannot be said that the assent was granted qua the repugnancy between the state law and the other laws for which no assent was sought or given. So that was the position in this case. Only this much has been permitted. Assent otherwise cannot be challenged. No judicial review is permissible on the assent, whether it was manifestly arbitrary and this and that. Only the coverage is to be seen. And in this case, there is only one law. It's nobody's case that there are three other laws with which our state amendment is contradictory. We have not walked considerable length as regards pleading is concerned, but in para 30 minutes of my written submission at page 12, I have given a judgment 2004-6 SCC, which says that there must be a clear pleading challenge. But of course, they have moved an application now, if your lordships are willing to entertain, but I have argued on the basis of first principles.
so you didn't complete the citation 2004.
2004-6 SCC, page 36, paragraph 38 and 39. And that is contained in volume 3 of the 3 volumes which were given by Mr. Sibal yesterday. I have given the pages, etc. at page 13 of my. Then I don't need to give it. I'm not reading it just because I need to. Should I read it?
Be faster.
Yes, I'm therefore moving onwards. I don't want to read this. I was myself looking at the watch. Now coming to culture, brothers. Please have my written note. I tried to extract as much as possible so that rest material we have enclosed.
Because Venugopal said there's a finding in Nagraj that this is not part of culture. Or in the form it is practiced.
That's right. So in the form, it is practiced, it is not. That's why our exemption says that Jallikattu, which is permitted by the culture, not that which is not permitted. Para 53, 55, 4, which your lordships are referring.
Yeah.
Now, my first submission is that fact that it is part of the culture has been legislatively determined by the state of Tamil Nadu's legislature. That determination is contained in the legislation itself. So there is a legislative determination. Number two, that determination is endorsed by the president's assent. So the burden will be entirely on the petitioners to demonstrate that even though it has been going on for n number of years, generations, and it begins with Pongal and goes on till May.
Matapam.
Yes. So therefore, the time period is fixed. The breed of cattle which will participate is fixed. It generally coincides with the village festivals which are happening, which may be religious festivals or otherwise, and it coincides along with them. And now even the mosques and the churches even they are not organizing. So this is a culture which is beyond caste, creed, and religion. And this fact is not disputed. Now, may I place it from para 13, page 13, page 13, para 31.
Of your notes.
Of my note, this is only to take, not in the time. I will take a lordship only through some judgments which are necessary. Since one of the objectives of the State Act is to enable Jallikattu to preserve the culture heritage, a question arises as to whether Jallikattu is actually part of the cultural heritage. Or it is, if it is so, then the people of Tamil Nadu would have fundamental right to conserve the culture and Article 29(1) of the Constitution, and state would be charged with duty to protect it. It is notable that Article 29(1) uses the word conserve, which is wider than the word preserve. Article 29(1) thus confers an active right to preserve, promote, and develop the culture. Then we have extracted from Durga Das Basu. With respect to Article 29(1), this court has held that its marginal note is misleading. The fundamental right to conserve culture extends to all sections of citizenry. The marginal note says minority. So lordships have in the following judgments held that marginal note is misleading. It is available to all sections. May I turn to page 14, Millets? It has been held by this court that Article 29(1) confers a right to conserve a language, script, or culture, and it is absolute. Unlike Article 19(1), Article 29(1) is not subject to any reasonable restrictions. The case of Jagdev Singh read Section 123(3) of the Representation of People Act 1951 in consonance with Article 29(1) and held that this section cannot be read as trespassing upon 29(1), and therefore asking to vote to conserve a language cannot be made a corrupt practice, not script practice, corrupt practice. In view of the above, the provisions of the PC Act and the Tamil Nadu Act have to be read and construed consistently with the fundamental right of the people of Tamil Nadu to conserve their culture, and has not prohibited the conduct of Tamil Nadu, Jallikattu. Looking at the matter from another angle and assuming that the fundamental right to conserve culture is amenable to some regulation, the regulation cannot extend to complete ban of the conduct of Jallikattu. In the context of Article 30 of the Constitution, which confers a fundamental right upon linguistic religious minorities to establish and maintain educational institutions of their choice, this court has held that the fundamental right, now this is a quote from the judgment, it has been held that the article has been couched in absolute terms, but has to be read subject to regulatory powers of the state as long as the substance of the guaranteed right is not affected. So therefore, Lord, I am conceding because of the subsequent development, although that judgment of Jagdev Singh is of 5 honorable judges, which says 29(1) is absolute. But I am saying, Lord, that much water has flown subsequently. And now we are, Lord, balancing fundamental rights, directive principles, fundamental rights and duties and so on. So, Lord, therefore, regulation is permitted, but you can't ban the culture. The balance has to be there to eliminate cruelties as much as possible. And I've given those judgments notes and paragraphs. Jallikattu is not merely an act of entertainment or amusement, but an event with great historic, cultural, and religious value for the people of Tamil Nadu. They, without any distinction to caste or creed, celebrate Jallikattu as a religious event. It also draws huge crowd of foreign tourists who come exclusively to witness the events. Jallikattu traces its origin to Indus Valley civilization, and there are terracotta tablets that depict the organization and celebration of Jallikattu. It's an artistic expression of valor, skill, grit, and determination. It requires intense training both for the bull and the participating humans. It brings out the integral relationship between man and the bull, and not only for the owner who rears, feeds, and trains him for participation, but also for the participant who is required to embrace it, bare-handed for fleeting moment. The embrace is by holding on to the hump. The participant's embrace results in no physical injury to the bull. References about Jallikattu are also available in Silapathikaram and Kalithogai, both ancient Tamil literature dating back to Sangam era and beyond. The sport Thaluvuthal dates back to the Sangam era, which means embracing the bull and not overpowering the bull. Historically, the sport was also used to choose a suitable groom for young women in the villages, but that's no more there. It used to be at one time.
Swayamvar.
Yes, so, sort of. The sport has been an integral part of Tamil culture and heritage for several millennia. Jallikattu is a religious and cultural festival sporting event which bears a religious significance to the people. Each and every event of Jallikattu is conducted during Pongal festival as thanksgiving for a good harvest, and subsequent festivals are conducted near temples. This shows that the event has great cultural and spiritual significance. Jallikattu is given prime prominence even in the school curriculum. The traditional and cultural significance of Jallikattu in its intertwining with the social cultural milieu is taught in the high school curriculum so that the significance is maintained beyond generations. An ancient rock painting is found in Karikayur village near Kothagiri of Nilgiris district, depicting people chasing three bulls with sharp horns and huge humps. An ancient rock painting is also found in Kaluthu Metupatti village near Usilampatti of Madurai district, depicting person trying to control a bull with hump.
Yes.
Also, a painting of a bull with hump is found at so-and-so Theni district. There has been a case study about Jallikattu movement in Tamil Nadu done by Rajiv Gandhi Institute for Contemporary Studies, New Delhi. The study is of March 2020 in para 1.2 and para 2 of the case study. It has been mentioned that Jallikattu is an ancient sport and has been invoked since the last 5,000 years. It refers to the seals of the Indus Valley civilization, Sangam literature, textbooks in castes and tribes of South India, volume 5 by Edgar Thurston, the gazetteer of the Madurai district, etc., to establish that it is an ancient sport of Tamil Nadu, which is part of their culture. So, the gazetteers are referred to and everything. Look, this is Tamil Nadu. Now, the question with regard to 29.1, when we look at 29.1, for a second, if your lordship looks.
Yes.
Any section of the citizens, you'll also see minority is there in the marginal note, but not in the main part. Any section of citizens residing in territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. So how do we understand this culture is the question. Given the facts which I have mentioned, And that's what I've tried to deal with in page 16 of my notes.
Yeah.
The Encyclopedia Britannica explains the advance from instinctive behavior to learned and freely variable behavior, patterns of which may be acquired and transmitted from one individual and generation to another, and finally to a system of things and events, the essence of which is meanings that cannot be comprehended by the senses alone. This system is, of course, culture, and the species is the human species. Culture is a man-made, can you just add evil, environment brought into existence by the ability to symbol. Once established, culture has a life of its own. In Encyclopedia Americana, culture has been explained. It says that predominant use of the idea of culture in contemporary anthropology concerns its signal marking of differences among human population on the basis of language, habits, customs, and modes of thought. It mentions that in the late 18th century German Enlightenment period, the idea of culture became objectified and it came to be recognized as a thing and end in itself. Encyclopedia Britannica also traces the emergence of sports and its conduct in close association with religion and notes the conduct of sports during fairs and seasonal festivals. It also deals separately with crowd behavior and refers to spectator violence in relation to football, soccer, baseball. In para 44, Romila Thapar in her book Indian Culture as Heritage states, every society has its cultures, namely the patterns of how the people of that society live. In varying degrees, this would refer to broad categories that shape life. And again, in the social sciences, culture gradually came to refer to the pattern of functioning in a society with its multiple facets, extending from the foundations to the many manifestations of actions and ideas. The articulation of groups that were not the elite came to be located in the cultural patterns, recognizing at the same time the interface between what had earlier been differentiated as being either art or craft. Yet again, she says civilization is an amalgam of patterns of living with much interaction. She describes heritage as that which is inherited and can refer to objects, ideas, or practices. The intangible heritage is the heritage of ideas and values that may be associated with objects or may be articulated differently, for instance, as performance. In his article, Idea of Culture, Terry Eagleton explains how in 20th century, the idea of culture assumes something of its modern meaning of a distinctive way of life. So long back, it used to be high culture, arts, painting, and so on. Then they had, even UNESCO has recognized that subsequently popular culture. And now they say way of life or pattern of living.
Yeah.
But these articles from Thapar, etc., I have passed on to your lordships. I'm not referring to that because I have elaborated. It is submitted that in case of Nagaraj, this court assumed that Jallikattu is part of the culture of people of Tamil Nadu, but held that the manner in which it is being held is not part of Tamil Nadu culture. The court did not examine the impact of 29(1). Therefore, that judgment is not decisive of the present issue. Evidently, the state legislature is not only legislatively competent, but justified in protecting the fundamental right of people under 29(1).
Yes.
Now, this is important note, para 47. In the Constitutional Court of South Africa, it's an 11 judges judgment, and it was all about the stud which a girl was wanting to wear in the school. And she was a Tamil girl. In the Constitutional Court of South Africa went into the concept of culture and its relation to religion in the context of the entitlement of a female student to wear a nose stud in school. The school had refused exemption from the prescribed uniform. An 11 judges bench observed that culture generally relates to traditions and beliefs developed by a community, and it can have a great deal of overlap with religious practices. With respect to the student, the court held that even on the most restrictive understanding of culture, Sonali is part of the South Indian Tamil and Hindu groups, which are defined by a combination of religion, language, geographical origin, ethnicity, and artistic tradition. Whether those groups operate together or separately matters not. Combined or separate, they are identifiable culture of which Sonali is a part. It went on to hold that cultural convictions and practices may be as strongly held and as important to those who hold them as religious belief. So this is very important, my lord. It's not what we think, my lord. We have to see whether the people of Tamil Nadu, my lord, think that this is part of their culture. Are to those who incline to find meaning in a higher power than in the community of people. It's said that cultural identity is one of the most important parts of person's identity precisely because it flows from belonging to a community and not from personal choice or achievement. And belonging involves more than simple association. It includes participation and expression of the community's practices and traditions. The practices and beliefs could differ from person to person within a culture. The particular practice need to be a mandatory tenet and need not be a mandatory tenet and could be a voluntary expression of the Tamil culture. The right to culture would protect the voluntary practices which are part of the culture. So this is an 11 judges South African court dealing with a Tamil girl. Then an article by Professor Chow from Hong Kong published in Human Rights Law Review. I've chosen this not only because it deals with all the UNESCO and everything. Deals with elusive notion of culture in the light of Universal Declaration of Human Rights, the works of UNESCO Committee on Economic, that is CESCR. He classifies culture as high culture, B, popular culture, C, culture as a way of life. This finds support in the writing of O'Keefe also. He explains how the concept of culture has expanded to include popular culture and culture as way of life. According to him, the meaning of way of life is very close to a group's habit of behavior, living style, or the worldview representing the totality of person's encounter with external forces, affecting his life, that of his community. In short, the sum total of material and spiritual activities and products of a given social group, which distinguishes it from other similar groups. It is no more limited to the notion of high arts and popular culture and acknowledges the distinctive features of way of thinking and ways in which people's lives are organized. This is accepted by UNESCO in its report 2001 titled Our Creative Diversity. Therefore, culture is no longer a consumer product, but an expression of the identity of an individual or community, including distinctive features, ways of thinking, and organization of people's lives. In the present case, apart from the material placed through counter affidavit, there is legislative determination. I've already mentioned that. Then when a Jallikattu event is organized during and around Pongal festival, the Tamil people not only participate in the cultural activity, but their participation is actually a cultural expression of their identity and also part of their human dignity. It is much more than an ordinary sport having a religious connect. The State Amendment Act consequently carries out the positive obligation of protecting the fundamental rights of the people of Tamil Nadu, not only in the Article.
Jallikattu is held how many times in a year actually?
Sorry, Milord?
How many times in a year is it held?
Only once, Milord, then from 14th of January, the Pongal, Milord, or the Bakar Sankranti as we call, Milord.
Correct.
And up to May.
Up to?
May. And once in a village.
That is immediately after the harvest.
Yes.
Yeah, only from January to May.
May.
And roughly how many Jallikattus have you empirical?
396 Jallikattus were held, in which 1,17,000 bulls, roughly approximately, participated.
January 15 to May.
Yes.
Once in the village, in the whole of the year.
Yeah.
Only once in the village.
In every village, it will be only once.
Every village.
Yes. No, not in every village, whichever village. The village has to approach the collector.
That's right.
Then the collector notifies those villages. And only there it can be. Of course, people, somewhere it can be held, people
Without following.
without that, all those things. But so But even counting the illegal ones, Lord, which were about a dozen or 2 dozen odd, Lord,
So roughly 395,
396.
396.
They were the notified,
That is in which year?
2022. Now, if 1,17,000 are participating, Lord, and the report which Peter relies upon is of 7 villages based on newspaper articles, assuming everything, Lord, what they are.
1,17,000 bulls participated.
Yes. And each bull participate once for that 30 seconds. And all players barehanded. So we are not counting amongst this the rejected bulls. Here are the participating bulls.
What is the discrimination argument of, I think, Shyam, that you are treating some bulls differently from
I'll
others?
come to that. I'll just finish this cultural aspect right there. So, Lord, in Pottaswamy's case, I have given the paragraphs where Lordships have said that the state does not have only a negative duty, but a positive duty to effectuate that right. I've given the paragraphs on 113, 125, 326. Then I go on to say, Lord, in para 51, that in the modern day world, one finds uneven development of societies. Not only different countries are different stage of development, but even within the country and states, different regions are at different levels of development. Equally, one finds that certain sports have become secularized and are not connected to any religion or culture. But in rural India, there are still certain ancient sports like Jallikattu, bullfighting, cockfighting, etc., which have been conducted since ages and with continuity, and is associated with religious festivals. In view of the aforesaid, it is submitted that it's a cultural event. Now, page 20 minutes, I go on to distinguish this with bullfighting. Bullfighting, is often bloody, milords. Sometimes there's a matador, sometimes there are 2 bulls fighting, and there are also bloodless. The point which I am placing reliance, I have given the judgments of Peru and all those, they are annexed. Colombia. So Peru, Colombia, Spain, all of them consider bullfighting to be a part of their cultural heritage. This is very important.
Yeah.
Even France, the Constitutional Court has struck down mullets. And recently somebody tried to put in a bill, but it was withdrawn.
In France, what was struck down by the Constitutional Court?
The local court, the legislatures, they wanted a prohibition. So they struck it down. In Spain also, in Catalonia, legislature passed a prohibition. The Constitutional Court struck it down, saying it's a part of cultural heritage. So this is a incorrect notion, my lord, that a activity which is in nature a sport or an entertainment or amusement cannot be a cultural, cannot have a cultural value. That's very important. You also see, Lord, those countries which were colonized by Germany, France, and Spain, all of them, Lord, in Africa, etc., Latin America, they have got football. We were colonized by England, Lord, so we have cricket.
Parts of the country football also.
Yes, parts. Goa and Bengal and
Kerala.
Northeast.
They play a lot of football in England also.
No, they didn't bring a football here, no?
No, the English actually brought the football here.
But there's, whatever the culture of cricket is there, football is now coming up. We hope it comes up. With such a huge country and not participating in cricket. It's an embarrassment. But that apart, not a point I'm trying to drive through is that a sporting event can also be a cultural event. And especially my lord, in the rural areas. Well, what do the farmers do? My lord, 70% of the bulls in this country are owned by small and marginal farmers. I don't want to load your lordship with all those statistics, my lord, but we have experience, my lord, about our country in different parts. Most of the bulls and cattle, my lord, they are owned by the middle level, small and marginal farmers. Now they can't, my lord, participate. What do? They go to cinema hall. How do they entertain, my lord? These entertainments therefore become a part of the culture of the rural people. The bullock cart race, my lord, is the easiest for them, my lord, as it happens in Maharashtra and Karnataka. When there is no need for telling, etc., my lord, the bulls are idle. So, my lord, and nobody is asking, my lord, that the bull should run as fast as the horse. In para 43, my lord, in Nagraj, it was said it's two hoof, two bit, cannot run fast as the horse. But horses they are not made to compete with horse. But how is this relevant at all? It is bull and who has to cross in 30 seconds.
No, possibly the judgment proceeds on the basis that bull is not a naturally running animal.
I don't know from where you get from books, my lord. 5,000 years the bulls have been participating in Jallikattu, and we are told that the bulls cannot run. Anybody can open, my lord. I don't mind, my lord. Just see, my lord, in the net, my lord, your lordship will see how fast 80% of the bulls cannot be caught by anybody. They just come out and dash. They are so trained. 80% of the bulls are never caught by anybody. Nobody can hang on it. They fail, they fall around, and they just lie still like this, my lord, because the bull may not injure them. So bulls have been running in this, my lord, Jallikattu for 5,000 years, and my lord, the judgment will tell us, my lord, that bull cannot run. There are bulls and bulls. These are special breeds. We are not talking about, my lord, generally the bulls. There are bulls and bulls. There may be a bull which has been castrated, the bull which may have been dehorned, my lord, so they become docile. These are all bulls with horns.
Yeah.
And it is for Maharashtra people and Karnataka people to see, my lord, whether they are the run which is of the bull is sufficient or not. And nobody is asking the bull to run at the pace of horse.
And there are certain other animals also which runs faster than these horses.
Lord, there can be a race for slow running also, slow biking.
Cheetah.
I remember,
Cheetah.
Yes,
Cheetahs are there.
faster. Yet
Faster.
faster, yes.
That doesn't mean that a horse is not capable of running.
Yes.
We are not
No, I may
conducting.
not be
We are
able
not
to-
conducting a race between these two animals.
That's right. I may not be able to run as fast as Mr. Krishnan Venugopal, but I can run a bit.
50 meters.
Yes, 50 meters dash.
But my friend has run far ahead.
Yeah.
So therefore, my lords, this I don't know, my lord, if your lordship wants, I can read these judgments. My lord, I have given the paragraphs. I have annexed the judgments. My lord.
May not be because you've given a detailed note now.
I have given the detailed notes. I have given the paragraphs also.
We'll have to go through that.
Yes, but the other point which I wanted to, the 2 points which I want to make on this foreign judgments. One, that bullfighting is recognized as culture. Second, my lords, that these judgments have tried to cull out duty from the aspect of environment, sentient being.
Cultural
Nature.
Can be regulated.
Yes,
Can be regulated.
can be regulated, certainly.
Should be regulated.
Should be. It has to be balanced with compassion, etc. to the whatever extent possible. As I said, whatever is inherent, my lord, which is unavoidable. For example, when from the Vadivasal, the bull is to come out, sometimes you have to, my lord, just prod it,
That's it.
nudge it to move to it. Now, you may call it poking and this and that, but whatever you may call it, I say, my lord, that this is not a cruelty, my lord, at all. If with a stick you just push it, no bull, my lord, ultimately they are animals, my lord. Sometimes they may sit down, so they have to be made to stand up, and move out of the arena. So all that limited minor things can happen, but yes, no
Necessary pain theory, necessary. pain.
necessary pain.
And that is recognized in Nagaraja also.
Yes.
Para 70 last.
Yes.
Para 70 the last sentence. It
That's
says
right.
further animals like
So
cows,
duty
bulls,
has been. I'm sorry.
it says like this, further animals like cows, bulls, etc. are freely used for farming, transporting loads, etc. That too for the benefit of human beings
That's right.
and thereby subjecting them to some pain and suffering.
That's it.
So that is taken.
That's the necessary pain.
That is taken note of.
So therefore, not the second aspect is that these duties have been culled out and sought to be balanced. In Ecuador case, my lord, as I said, my lord, they have tried to weave out from the nature, etc., a subservient right. So you may call it a subservient right, you may call it a duty of compassion, and whether draw it out from sentient being, draw it out from nature, environment, or Article 51A, ultimately they cannot override the fundamental rights. They have to be suitably coordinated and balanced, my lord, keeping that the fundamental right,
Yet,
they are subservient. Ecuador says that they are subservient to the human rights.
Okay.
So I'm not reading, your lordship may kindly go through this. There you go. My lords wanted the Ecuador judgment, which we were able to take out subsequently.
you've got it, I thought.
Your lordship got it?
On that day it was made available.
Not we given it.
Solve it.
You've given it.
I will just give a piece of paper, the paragraphs.
You can make it available. You give a copy.
You can
for-
pass on, Mr.
You
Dwivedi.
can pass it on.
All right.
Pass it on, please.
You have it, now.
Yes.
Now, with that, I come to this question of Article 14, Lord, manifest arbitrariness rules. So my submission is not that that is delicate to is part of culture, and state is obliged in law to act positively to protect it. Then balance it not with the duty cast. Now, page 22, my lord, is where I deal with this. One aspect may be noted, my lord, that the question which has been framed doesn't, my lord, contain any of this manifest arbitrariness independently. The question framed is, does the Tamil Nadu Amendment Act go contrary to Article 51A, G and H? And could it be said, therefore, to be unreasonable and violative of 14 and 21? That's the question framed, but I don't mind my lord answering what they have argued. Now, my lords, one question which I wish to convey, my lord, and request your lordships to decide is, how do we, my lord, what are the parameters of manifest arbitrariness? Is it a subjective phenomenon, my lord, that in a particular case, the learned judges think, my lord, based on their, my lord, feeling of how it should be, and then, my lord, we decide that it is contrary to that conception, and hence, my lord, manifestly arbitrary? Or is it, my lord, something which has to be grossly or shocking, my lord, to the conscience? To that extent, my lord, you have to go to hold manifest arbitration. What is otherwise, my lord, the principle was laid down by Justice Nariman, my lord, departing from McDowell, my lord. In McDowell, he had appeared as a counsel, and Justice Jeevan Reddy, my lord, did not accept it, that legislations cannot be struck down. But then, as a judge, my lord, he ruled that that is available. But that's aside, my lord. He was entitled to. He says that now with Menaka Gandhi's free, fair and reasonable requirement in Article 14 and 21, we have gone back to the due process scenario in America. Question raised before the 9 judges in Aadhaar by me was, Lord, is that so? Are we bringing back due process which was expressly rejected by Dr. Ambedkar in the Constituent Assembly?
Possibly Maneka Gandhi does introduce
So therefore, I'm
a
asking.
different
Therefore,
levy.
I'm asking, my lord, how do we go about it? But in 9 judges, Justice Chandrachud, my lord, speaking for the majority, says that no, we are not bringing in due process. And if your lordship may just note paragraph 290, the judgment is 2017, volume 10 SCC, page 1. Para 290 to 296. Maneka Gandhi has been considered. Dr. Ambedkar's speech has been considered.
But Mr. Dwivedi, 14 kind of confers a right on a citizen
Yes.
to question legality of a statute on the ground of arbitrariness. Why should manifest arbitrariness shall not be an assault weapon
I'm not
from
saying
the
that.
citizen's point of view?
I'm asking posing a different question. I'm posing a question. How is this manifest arbitrariness to be determined? Of course, case to case.
One answer is that we know it when we see it.
But the point is, my lord, your lordships have to declare the law for the nation, my lords. So when your lordship will be declaring it manifestly arbitrary, my lord, we must know not only the lawyers, but the people, my lord, as to how your lordship's mind functioned, my lord, when the lordships held that it is so. Of course, my lord, we know, my lord, that by now, my lords, at the fag end of our careers, that is ultimately what your lordships decide. But then, Lord, that's the majesty of this process, that when your lordships decide, your lordship tells us, Lord,
Not any of our court. This is by an American
yes,
Supreme Court judge,
yes, yes. Your lordship is right.
Justice Porter, possibly.
Yes,
Commenting on obscenity, what it is.
Yes, yes. That's right. There is an element. Even Justice Patanjali Shastri, my lord, has said, my lord, that some element of values of the judges is bound to enter, my lord, into that. So there's no objection to that, my lord.
Some element of the legal culture.
Correct.
It's not only the judges are not.
But even judges, it happens, my lord, we have been watching, my lord, my lord, there were days where, my lord, when rent control matters used to come before Justice Desai, my lord, ideally just had to say, my lord, that's a tenant's matter, that's notice you should stay. So judges' inclination, my lord, does count.
But the social culture.
But I will not call it manifestly.
Social culture was also different at that point of time.
Yes. That's right. So with changes in society, my lords, everything changes. I'm on a different question, Lord. Some parameters, please lay down. That's what I'm asking, because high courts are also there, my lords. High courts can also apply Article 14, my lord, to judge the validity of acts and regulations and so on. So manifest arbitrariness is not sufficient in my humble submission, my lord. Something more needs to emanate so that one can judge and apply those tools, the parameters. And I submit for your lordship's consideration that it should be so shocking, and because after all, you are dealing with legislation. And what happens, my lord, in legislation, that there is a presumption of validity. Then there are constitution benches saying that the legislators understand the needs of the people. Then number 3, my lord, your lordships have said that wide latitude will be given in matters of policy, legislative policy. So with all these, my lord, like a batsman in the cricket match, my lord, when we stand up, we wear with all these pads and gloves and thigh guards and everything, my lord, presumption of validity. So, and which your lordships have been kind enough to extend to the legislation. So, given all these things, and then also the Principle and Evidence Act, that official acts have been done regularly. Judicial restraint. So, all these principles will have to enter into while judging manifest arbitrariness. And that's what, my lord, has been laid down. If your lordship just note down paragraphs 290 to 296. I will just read, my lord, from 292. In dealing with a substantive challenge to law on the ground that it violates a fundamental right, there are settled principles of constitutional interpretation which hold the field. The first is the presumption of constitutionality. I'm sorry, my justice has got it. Page 495, bottom 292.
Yes.
In dealing with a substantive challenge to a law on the ground that it violates a fundamental right, there are settled principles of constitutional interpretation which hold the field. The first is the presumption of constitutionality, which is based on the foundational principle that the legislature, which is entrusted with the duty of lawmaking, best understands the needs of society and would not readily be assumed to have transgressed a constitutional limitation. The burden lies on the individual who asserts a constitutional transgression to establish it. Secondly, the courts tread warily in matters of social and economic policy where they singularly lack expertise to make evaluations. Policy making is entrusted to the state. The doctrine of separation of powers requires the court to allow deference to the legislature whose duty it is to frame and enact law and to executive whose duty it is to enforce law. The court would not, in the exercise of judicial review, substitute its opinion for the wisdom of the law enacting and law enforcing bodies. In the context of Article 19, the test of reasonableness was explained in the erudite words of Justice Patanjali Shastri in V.G. Rao's case. It is most important in this context to bear in mind that the test of reasonableness, wherever required, should be applied to each individual statute impugned, and no abstract standard or general pattern of reasonableness can be laid down as applicable to all cases. The nature of the right to have been infringed, the underlying purpose of the restrictions imposed, the extent and urgency of the evil sought to be remedied, disproportion of the imposition, the prevailing conditions at the time should all enter into the judicial verdict. In evaluating such elusive factors and forming their own conception of what is reasonable in all the circumstances of a given case, it is inevitable that social philosophy and the scale of values of the judges participating in the decision should play an important part. And the limit of their interference with legislative judgment in such cases can only be dictated by their sense of responsibility and self-restraint. And the sobering reflection that the Constitution is meant not only for people of their way of thinking, but for all. And the majority of elected representatives of the people have been authorizing the imposition of restrictions imposed, considered them to be reasonable. The court, in the exercise of its power of judicial review, is unquestionably vested with constitutional power to adjudicate upon the validity of law. When the validity of law is questioned on the ground that it violates Article 21, the scope of challenge is not confined only to the procedure of deprivation of life, and liberty is fair and just reasonable. I just come to 296 only.
We'll read it, we'll go through the paragraphs, you mentioned it.
All right.
Otherwise, we have to save time, we have to conclude today.
In 296, they have said, Lord, that due process doesn't apply. So, Lord, my argument partly was that it does, this theory, Lord, is go back to McDowell. But they said, no, after Maneka Gandhi, etc., now this can be applied to substantive law also, but with all this padding rules. And then now, Lord, the other thing.
We have to do the Maharashtra round also, Karnataka.
So, the learned solicitor is dealing with it, Lord. He said he'll take half an hour.
That's it.
Mr. Rohtagi will take half an hour. So, we'll finish by not beyond 3 minutes.
That's it.
No, I'm all of that. I'm trying to finish before lunch.
Yeah.
Now, Malak, at page 23, I have set out judgments which show that merely on the basis of Article 51A, you cannot strike down a law. Paragraph 61.
Cannot strike down.
Yes.
Fundamental duty.
And if Article 21 and 14, both of which use the word person, there is no fundamental right, Lord, and Justice Radhakrishnan was wrong on that. Hold it. A fundamental right. That was one important underpinning of that judgment. Apart from that repugnance, it was 21. Repugnance has been cured, 21, Lord, is erroneous. And he doesn't discuss this aspect at all, not in detail. So again, Lord, I am not reading those judgments. You also will see, Lord. It is one thing to use 51A for interpreting or for balancing at the utmost. But by itself, it cannot be used. For example, directive principles cannot be used by itself. Otherwise, everybody would be asking for a mandamus to impose prohibition or something because they don't want it. And most states, depending on that, revenue will be extinct.
That's right.
So, Lord, skipping that, now I come straight away, Lord, the question of finding of fact, Lord, argument. That is sought to be overruled. My first response to that is
Para 53 to 55.
yes. That the finding of fact was actually summed up in 53-55, that the manner in which, that is one.
And you have to correlate it to para 31.
31.
Of the
It was
judgment.
pointed out, Mr. Simple. So
Yeah.
yes. The second thing is not that a finding of fact in every case depends upon the facts which are produced in that case. They are never in absoluteness. In fact, Lord, it has been said that most of the time, Your Lordship, when it records the finding of fact, Your Lordship says that it appears on a perusal of the affidavits, etc., that this is so. And there was a report of Animal Welfare Board, Lord, which is a statutory body saying something. Today, they are have a different version to state. PETA, of course, Lord,
The basis is completely changed.
change. The third aspect is, Lord, that the finding of fact has had two parts. The first part was that there is cruelty being practiced. And in 2 or 3 paragraphs, in great details, Lord, from the affidavit of the board, it was recorded. The other part of the finding of fact was that because of his anatomical behavior, nature, and behavioral nature, and they being fearful inherently. So my answer is not that the second part is being taken care of by 11.1 read with the rules. And the fact that PETA has only spoken about 7 events out of 396 is indicative of the fact that
How
there is
will 11.1 deal with the anatomical part?
no second part,
Second part.
cruelty part.
That is the first part. You said first.
Oh, I'm sorry, I stand corrected. The first part of cruelty has been dealt with by 11.1 is preserved, except to the extent Jallikat 2 it is inherent. The second part about inherent, that is taken care of by the exemption.
Yeah.
So therefore, Lord, there is a completely different scenario today before Your Lordships. And in fact, Lord, the judgment of Tamil Nadu versus Kerala in para 155, that is 2014-12 SCC 696.
Paragraph?
155, 2014,
Yeah.
12 SCC 696, State of Tamil Nadu versus State of Kerala, that's that dam matter, no? Height of dam, para 155. That supports our case because it's expressly said that if the circumstances have changed, then a review can be sought. So I have dealt with this lot in page 29 to 31 of my note. And then comes not the aspect of this non-retrogression.
Mr. Dwivedi,
Yes,
you see the circumstances change. If you just go back to para 18 of Nagraj,
yes,
because you see what they said is they try to run away from the arena, the bulls, but they can't do it because the arena is completely closed. But we are getting a situation here from the chart that has been, the picture that has been given,
yes,
is that they go on to the, after the holding arena, then the running arena, and there is open space.
collection point.
So there is no enclosed, totally enclosed arena
Yes,
where this particular paragraph 18, perhaps there is a bit of a misunderstanding then.
that's right. I'm grateful for pointing this out. No? Now, my lord, there is a clear passage given.
No, that's what I'm trying to say. There's a bit of a distinction on the factual aspects that were noticed in Nagraja as compared to what is being presented now,
Presently, no, sir.
or the legislature might have had in their mind.
That's right. That's right. Now, my lord, on view of the rules, the area prescribed, everything has been done so that there is a clear passage. In fact, my lord, sorry,
Yes,
in fact, my lords, some of the photographs which your lordships must have seen, my lords, your lordship will find that when the bull is going back to the village after having taken part, then on the way, my lord, the owner is carrying, the crowd collects and the crowd, my lord, harasses.
That is the collection here.
So one that is, no, that's on while going back home outside the collection area.
Outside.
Please see the photographs again. You'll also find none of those individuals are dressed up as a participant. So the spectators, not they collect around and they not. So that is crowd misbehavior. One, it happens in a number of sports, not particularly football, etc. We have seen not the crowd misbehavior. But I have myself not told the authorities that your duty does not end at the collection point. You must ensure that when the bull is being taken back, then at least up to the market area, etc., until the bull leaves that, this kind of a crowd collection doesn't happen. Because some of the injuries which are pointed out happen there. In the bull area, a stray case could be if the bull instead of going after going to the collection point wants to come back in its rage. They collide or something.
Could it be because you are prohibited from administering alcohol beverage to the bulls,
Yes.
but it is not applicable to the spectators?
Yes, not. That's right. Of course, that's possible.
The humans do it outside the arena.
Yeah, that's right.
Everywhere the crowd misbehavior, one of the reasons for it is that excitement.
But this World Cup, we are not seeing that kind of a thing.
Yes.
They have prohibited beer, etc.
But some time back, it happened in the cricket match between Afghanistan and Pakistan. But that be that as it may. So I'm grateful for this paragraph. Sir. So, Lord, one, the basis of the previous judgment has been cured by taking care of, by taking the route of 254 and having the assent. Second, Lord, we have pointed out the errors in holding that 21 gives a fundamental right. And third, Lords, there are other errors in this, which I have already pointed out and Mr. Sewell pointed out. Now, coming to non-retrogression, Lords, my learned friend should have mentioned it to your lordships in Navtej Johor's case, that is 2018-10 SCC 1. This is on non-retrogression now, Lords. a paragraph was read, my lord, from Justice Deepak Mishra's judgment. That's not the majority judgment. Justice Chandrachud and Justice Nariman my lord, don't refer to that. The other error committed by them was that there is some other reference of non-retrogression, Lord, in Siddique's case, M. Siddique versus Suresh Das, which they did not refer. But in fairness, my lord, I have pointed out in para 88, 2020, volume 1, SCC, page 1, para 102, where, my lord, the legislative non-retrogression was talked about. Not that in judicial review, based on non-retrogression, my lord, a provision can be struck down. You all shall recollect in Places of Worship Act, my lord, it has been said, my lord, that 15th August is the deadline cut-off date. The character as on that date it will be maintained. It's challenged, but that's a different thing. So in this judgment, my lord, while dealing with that Ayodhya matter, this court talked about legislative non-retrogression. Because the law is saying, not the court is saying. Apart from these two judgments, there are no judgments where this court has applied the doctrine of non-retrogression. It is a doctrine, my lord, which is not yet firmly rooted in US. The US court itself it had applied this doctrine in the context of race cases. For example, that you have abolished segregation. Now you can't go back. But that is not directly connected to the equality clause. So this is a constitutional provision which they style it as non-retrogression to prevent the legislature from going back after conceding a right, valuable right. So they were mostly race cases or voting right cases, that if you have granted not a voting right to citizens up to 18 or 21, now if you want to go back. So, but it has received lot of criticism. I have annexed one such in para 86. The Lordship may note what in para 86 I have annexed. So it is much better, my lord, to deal with ultra-virus based on Article 14, 19 and 21 rather than, my lord, strike down a principle, the statutory enactment on the basis of non-retrogression principle, which is not yet firmly, my lord, rooted in US even itself.
Yes.
It happens, my lord, it's very enchanting, my lords, to borrow, my lords, narrow tailoring, etc. Things get settled down in due course of time, you know. But to just mechanically adopt the principle and apply it, my lord, will cause serious. So every time our legislatures are having plenary powers, they can legislate prospectively and retrospectively both, subject to the constitutional fundamental rights. So therefore, to say that there can't be retrogression, and lastly, in our case, no retrogression is involved. Until 2014, Jallikattu was being conducted. It is only when the central government passed a notification under Section 22 of the PC Act, saying that bull is not a performing animal, then this controversy arose and it has been rectified promptly. So consequently, there is no rectification involved. And at the end of the day, the Lordships, my Lord Justice Joseph wanted me to respond to that classification.
That's what are the contentions raised?
But classification, sub-classification, I have dealt with in para 32, my lord. Para 32, if your lordship will see, my lord, 37. I have extracted, my lord, from that also.
Yeah.
The sub-classification of bulls has to be tested on the same twin test, my lord. Is the classification having a rational objective? So we are preventing other bulls which do not have the hump, etc. So these are special breeds which alone can have been historically used for this. So it is limited to those bulls.
Only with the hump.
Yes. And the hump bloods
Only in the alignment of the legs,
alignment, yes.
in alignment of.
That was the right.
Not otherwise.
Yes.
It can bear the
Yes.
embrace.
Embrace.
That's right. So therefore, that is not. And lastly, I say, Lord, let's not forget also, Lords, the bulls are facing a much more cruel world today. Why I say that? Tractors have come in, harvesting machines have come in, transport
Not
vehicles are there.
Not needed anymore.
So, Lord, what do these bulls do? Where do they go? PETA, Lord, unfortunately, there's no facts, Lord, but I investigated and found, Lord, that bulk of the meat goes to US, Lord, to where PETA belongs. And most of the mutton, Lord, which is the meat which is going, beef which is going exported, Lord, is from UP, Delhi, and Lord, this area, not from the south. So what happens now, Lord? Are we pushing these bulls, Lord, to save them from this small suffering and pain to the slaughterhouse, Lord? This is the question which I am posing, Lord. Let's not forget this, Lord. And if the legislature wants to avoid that, Lord, can it be said to be manifestly arbitrary, etc.? So the only destiny of these bulls at young age would be the slaughterhouse. It's a matter of common knowledge, Lord, that this mechanization is happening.
They are used to fight up to what age actually? From between 2 to 4, 7. Somebody said 2
to 6 years.
2 to 6 years. And they survive till 20 years.
And round the year, they are maintained by the farmer for this occasion. See the larger picture. Forgetting whatever PETA may be having, that by your side I said, there isn't any material on record to say that. But this is definite. Your lordships can take judicial notice that because of mechanizations, harvesters and transport vehicles, the use of these animals as draft animals and pack animals has drastically reduced. So what is to be done? For what will the farmer maintain them? Either just leave them, abandon them, and then the farming will be disturbed. Where will the farmers go? Into anybody's farm. It will be like a bull in China shop. So therefore, this cannot be overlooked at all, which is completely lost sight of. We are overemphasizing, my lord,
Animal rights.
the pain, etc. But surely, my lord, frying pan and fire, my lord, is much more cruel. Let them live their life at least, my lord. We can tolerate castration, etc., my lord, which destroys their life. Branding. Why is branding done? Because I must know it is my bull. For this purpose, identification purpose, branding is necessary. How cruel that branding is, how painful it is. So, lordships will look into all this aspect. This is much less, and it's.
You place the other side of the picture. Place the other side of the picture. You have to conclude by 3. All that we are saying. Whatever the reply will be concluded today. This case will be reserved today. Isn't it?
After solicitor argues, we will have 5-10 minutes for each.
No, see, whatever is said, that is taken.
We will not
You don't have to repeat
we will
again
not-
and again. There's
we-
no
we-
the
we-
number.
Give us some time tomorrow, maybe short time.
Today.
Lord,
We are just completed.
Wait, please.
Yes.
Lord, I appear for the central government
Yeah.
and also for state of Maharashtra.
Oh, you're doing the
Yes.
Maharashtra also.
But my lord.
Yeah.
But I'm not going to repeat any of the submissions already made. And so far as the central government is concerned, my lord, I know the limited role which the central government would have
Correct.
in facts of the case. Therefore, my lord, the time limit fixed by my predecessor, Mr. Trivedi, for me, my lord, I'll abide by. Lord, kindly have a look at, my lord, just for my satisfaction, section 11.
Yes.
Treating animals cruelly.
Yeah.
Correct, my lord? Lord, my learned senior, my lord, Mr. Sibal has taken your lordship through the entire scheme. But please come to 3. 3 carves out an exception.
Correct.
And series of exceptions are there, my lord. The dehorning of cattle, destruction of stray dogs,
Yeah.
extermination or destruction of any animal, any matter dealt with in chapter 4, or my lord, E. The commission or omission of any act in the course of the destruction or preparation of destruction of any animal as food for mankind, unless such destruction or preparation was accompanied by infliction of, please note, unnecessary pain or suffering. Your lordships were also taken through section 28. Broadly,
Correct.
the act provides for 2 things. A, no cruelty. B, even if there is an act which may involve cruelty, no unnecessary pain or suffering, and the statute,
Yeah.
the legislative scheme, goes to the extent of permitting not just cruelty but killing, either for food or for sacrifice or, my lord, any other purposes your lordships have seen. So the limited purpose, my lord, within which your lordships may consider exercising judicial review is when the state legislature enacts an enactment carving out yet another exception. Would it per se be repugnant? Because in my respectful submission, even the state would be exercising powers under entry 17 of list 3, concurrent list, and therefore, my lord, I, in my respectful submission, do not think it can be seriously disputed that there is legislative incompetence. The argument at best is both legislatures are competent, but there is some repugnance.
Yeah.
But my respectful submission is, in law, there is no repugnancy at the outset. Because it is only carving out one more exception with the very same condition which the statute stipulates.
Can you see there is no repugnancy?
So there is no repugnancy would be, my lord, that something which the parent act says and the state act says something contrary to it. Lord, I am coming to that. Lord, irreconcilable repugnancy is the only test your lordships have considered to set aside. Ancillary encroachment also is permissible, my lords.
No, but the state amendments,
Yes, my lords.
in their own right, they would be repugnant. That is why the assent was sought.
I'm conscious of that. We may not travel into the part whether there is any repugnancy or not. Because there is an assent, my lord, sought and granted.
Correct.
But, my lord, as a proposition,
You're saying even without the assent.
without assent also, my lord, what they have done is carving out yet another exception to section 11, which, my lord, permits exceptions for more severe things like killing also. Now, my lord, they have done this. Lord, so far as courts are concerned, my lord, your lordships, my lord, are fully aware. Your lordships would not prohibit a particular activity if there is a statutory enactment in place. Your lordships would, my lord, merely examine the constitutionality of that particular provision and hold whether the provision is otherwise incompetent by the, so far as legislative competence is concerned, arbitrary, discriminatory, classification is reasonable, etc., etc. Lord, your lordships would be able to say that no permissible Jallikattu or any race, only in absence of a statute. Once the statute is in force, your lordships would examine the validity of the statute. Lord, that though we are not, my lord, in the era of, my lord, Vishakha judgment, where there is a vacuum and your lordships are trying to, my lord, fill up the vacuum. Lord, having said that, let me, my lord, first, I'll, my lord, give my written submissions, and I have quoted the paragraphs, and except one or two judgments, my lord, I am not going to read anything. I have quoted relevant parts. But before, my lord, I do that, let me point out, my lord, what is the position in the state of Maharashtra, because there is some distinction. Lord, I fully support the legislation of all three states, Tamil Nadu, Karnataka, and Maharashtra. But in Maharashtra, my lord, I must, my lord, make one thing very, very clear. The impression possibly, my lord, maybe unintentionally, which is communicated on petitioner's side, that any bull is picked up and he takes part in either Jallikattu or in race. My lord, nobody has challenged, my lord, and kindly, my lord, allow me to, my lord, develop this a little, my lord, in detail. We have horse races. Any horse doesn't participate in Derby or any other race. There is a special breed. The breeding takes place, the training takes place, taking care is a separate care taken, veterinary care is taken, and practice takes place. And that is what, my lord, happens in the state of Maharashtra. The bulls which are participating only in racing, there is no human element.
Bulls are trained. Bulls are being trained.
Lord, there is a separate breed. They are not deployed in agricultural activity or as a transport. Like, my lord, a race running horse will not be in, my lord, a horse carriage.
There is a pleading for that.
Lord, I'll show that. I'll show that.
Pleading is there.
Yes, sir. Pleadings are there. Lord, we in the state of Maharashtra constituted an expert committee, and there is an elaborate, detailed report on this one, which we have placed on record at the relevant point of time. What happens is, this special breed, specially trained and protected for that, Lord, they run the race. The general racing arena is 200 to 300 meters, but the law permits maximum 1,000 meters. Not more than that.
1 kilometer.
1 kilometer. That's the maximum permissible, but generally the practice is 2 to 400, my lord, I will say, to be on the safer side, which, my lord, is completed within 20 seconds. Because the expert committee says bulls do run. My lord, my lord, it is sufficiently, my lord, elaborated before your lordships in Nagaraja judgment, my lord, several presumptions, my lord, possibly may not have any factual foundation, that bulls are basically by nature not running, flight and fight, my lord, etc., etc. My lord, there are experts which have gone into. Kindly, my lord, now have, my lord, that expert report. My lord, your lordships would find that in volume 2. My lord, there is a separate volume, my lord.
Take it.
There is a separate volume, my lord, or volume 6.
Convenience compilation.
My lord, can I hand over separately?
Separately, that's better.
Don't take it that I am doing it for the first time. It is already on record. This is only for convenience.
Green.
And, my lord, obviously, I will not read the detailed report. I just point out, my lord, what they have considered and what are the conclusions drawn. Please see, my lord, report on running ability of bulls. My lord, kindly come to the index, the contents, my lord. and 5. Your Lordship gets one of the contents.
Yes. Yeah.
5. Bull race, custom and tradition in Maharashtra. They trace it, they collect the evidence, and they record their findings. Lord, you're considering, my lord, the nature of judicial review which my lords would be exercising.
Yeah.
Lord, I'm not going into the reading of, my lord, how they have arrived at a conclusion, etc., because that would be something akin to an appellate power, which my lord, if your lordship wish, I can take your lordship through, but that may perhaps not be the scope of the present proceedings. Then, my lord, 6, recognized native breeds of bovine and equine species of India. Then types of bull cart races or events in Maharashtra, bull races in other countries, races of other animals, domestication of cattle, comparative anatomy of horse and bull. Look, they've gone into this. These are all, my lord, experts in the veterinary and their respective zoology field. Stress response and adaptation in animals, comparison of flight and fight response in bulls and horses. Lord, so far your lordships, my lord, were only informed. Now your lordships have a report of experts on this. Biochemical and physiological adaptation to training, exercise and running. Summary and opinion of the committee. Your lordships, my lord, kindly go through. They have gone into in-depth, my lord, analysis is done. And, my lord, if your lordship, my lord, see, my lord, say, for example, page 20, the draught bull and race bull, they are different. The breed is different. The breeding takes place separately. My lord, the last year I am told, the best bull of this breed who participates in racing was sold for 31 lakhs. These are not, my lord, bulls which are employed in agricultural operation or for carriage of goods. They are like race horses. They are used only as race bulls.
Yeah.
Kindly see page 44. Native breeds of bulls in Maharashtra. My lord, all bulls, my lord, are considered by them. My lord, I am not going into it. And, my lord, they decide, my lord, that this is the category of bull which needs. And your lordships would find page 53. This is the race which takes place. Page 53.
Yeah.
Your lordship has, my lord, the photograph.
Yeah.
The bulls compete inter se. Lord, why, my lord, I'm showing this. Lord, Article 48A provides for, I'm sorry, 48, but not 48A. Oh, may I read? I'm sorry, your lordships, my lord.
No, we have seen it. We have seen it. So actually, there will be 2 bulls. Actually, they
Two.
run in pairs.
Yes.
Always.
The bulls are generally in pairs.
Generally in pairs.
My lord, therefore, my lord, we generally say pair of bullocks. My lord, in English also, my lord, we rarely say bullock, pair of bullocks. My lord, that's
So where does the pain come actually? Which part is the pain actually? What was identified in Nagaraja as causing pain?
Lord, Nagaraja doesn't unfortunately go into this aspect of the race at all. And, my lord, I can say this, except the last para which says that Jallikattu and Maharashtra bull race is not permissible. There is no discussion on this. Please, if you don't.
They referred to it. They referred to it.
So they have not, my lord, the Nagaraja judgment does not locate any pain or inevitable suffering. Lord, if your lordship would like to see para 25 of the Nagaraja, my lord, judgment.
That's okay.
We have
seen that. We have seen
your
that.
lordships have seen that.
We have seen that.
So, my lord, thereafter, my lord, the study takes place in 2018.
Yes.
Whatever was the basis or foundation or lack of it, my lord, in Nagaraja was removed by the state legislature.
Whose you have removed and what is the basis? What did
Yes,
you
my
do?
lord, there was an act of parliament, act of the legislature,
Correct,
my lord, which is, my lord, similar to Tamil Nadu.
correct. But then what did you do to remove I mean, what was found? That's why we asked you, what is it found painful? In Nagaraja, the rate.
The Nagaraja
Tamil
doesn't.
Nadu, Tamil Nadu, the rules have been completely changed.
My lord, kindly see, my lord,
What is the
Nagaraja.
change brought about in Nagaraja?
Look, can I read Nagaraja page 25? So far as this race is concerned, look, there is no pain location, my lord, location of pain. No, I'll just, my lord, allow me to read page 25, para 25. We notice, Lord, your lordship,
Yes.
Nagaraja. Look,
Yes.
kindly see para page 570.
Yeah.
2014, 14/7.
Page 25. I'm sorry, page 578.
It's on 14.
14/7.
14, 47.
Some, my lord, shouting and the light. That's how, my lord, they say. But no, not pain. We notice in various parts of Maharashtra, your lordships are with me, my lord, on that. Varied types of bullock cart race are being organized. Bailgada Chariot is a race where no person rides the cart. In such a race, at times, bullocks are brought to the venue blindfolded through trucks and let free. My lord, I do not know from where, my lord, the Honorable Court, my lord, was pleased to, my lord, find this. Free through a ghat, either side of which spectators, large in number, assemble. Due to sudden exposure to the light after unfolding and huge noise source made by the spectators, bullocks get terrified and run in straight on the slope. But there is no slope, it's on the plain ground, number one. Number two, Lord, the bullocks are trained the way horses are trained. Your lordships have not seen the race, horse races, at least in the television. They are never even distracted, forget terrified. They are not even distracted. They are trained that way, my lord. The training takes throughout the year, my lord, year after year. And my lord, rules ban the slope, my lord. They are supposed to run on the Medan, my lord, the ground. Due to sudden, many of the bullocks are tortured and whipped to make them run, and the price is decided on the basis of time taken to cover gap of approximately 300-meter distance. Races are also there where bullocks have to cover 10 kilometer and more. Lord, Lord, there is nothing to support this submission. Lord, 10 kilometers during the course of race, cruel practices like beating, twisting of tail.
Paragraph 2 of the judgment, because it was directly in issue. Because what happened was that the government of Maharashtra prohibited bullock cart races.
Correct, my lords.
That's
My
how.
lord, thereafter, my lord, this was.
It is not obiter or anything like it. It is actually directly in issue.
My lord, thereafter, my lord, the basis of that, that is removed. What is the?
It is not obiter.
Yes, yes. I didn't say obiter, my lord. But these are not, my lord, the factual findings arrived at after, my lord, any assistance, I'll put it, my lord, that way.
The government of Maharashtra actually prohibited the bullock cart races.
On these grounds, yes. Para 2, your lordships are right.
Yes.
The 24th of August 2011. But my lord, it doesn't say they prohibited on the ground that there is some pain or there is some tail twisting, etc., etc. Now, my lord, even that has gone. Your lordships, my lord, are reading Nagaraja in a separate regime. I don't wish to, my lord, repeat what is already argued. Now, we have a separate regime, validity of which is in question before.
Correct.
Now, my lord, see, my lord, the Act. Volume 6, my lord.
Let us see the act.
Of the convenience compilation, my lord, volume 6.
We wanted these acts.
Standalone.
Put it in my written note, we can read from there.
In all acts, yeah, we, my lord, I think someone who is common to all can do that.
Yes,
Your lordship wanted the amending acts,
yes.
but that's already part of the compilation and given your
But if it is not there, my lord, we will ensure that the compilation is.
Now there are compilations of compilation.
Lord, I've given your lordship a chart with the relevant provisions culled out of all the acts that are given separately. I can supply fresh copies that are given in my slides.
No, my lord, there, my learned friend is right, Mr. Luthra is right. There is a my lord, convenience compilation of documents, volume 1.
Apart from this, Mr. Mehta, I've culled out I've given you, we'll get another copy, just culled out the relevant provisions of each amending act. Along with the chart, but that was given, I'll give fresh copies. for convenience.
Your lordships have, my lord, this convenience
I will
compilation.
get that.
There, my lord, whoever has compiled this, my lord, but has,
Compilation has been very painstaking.
yes, my lord. No, they have given, my lord, even
Mr.
notification.
Mehta, it was given like this, but I'd given it in writ petition civil 24.
Anyway, the double compliments, but even the first one was very good.
Mr. Mehta, it's a rare day. I will remember this. and
Yes, yes.
you have
So
enough-
kindly come to, my lord, page 141 of the convenience compilation. 141. So this is really wider. This encompasses wider.
Whatever bill is there, will be given separately. I don't have. Just take it. Baad mein do.
Yes.
Yes, my lord. First, whereas it is expedient to amend the Prevention of Cruelty to Animals Act in its application to the state of Maharashtra for the purpose hereinafter appearing, it is hereby enacted. My lord, kindly turn the page over, my lord, page 2. Bullock cart race is defined. Bullock cart race means an event involving bulls or bullocks to conduct a race, whether tied to cart with the help of wooden yoke or not, by whatever name called, with or without a cartman, with a view to follow tradition and culture on such days, and in any district where it is being traditionally held at such places as may be previously approved by the district collector, and also known as Belgada Sharia, Chakadi, or so and so in the state of Maharashtra. So, my lord, first of all, define. Second, it can be done, my lord, in furtherance of tradition and culture, which is now, my lord, by a report of a committee which is not under dispute, held to be culture and tradition, and places where traditionally it is being held. And fourth, only with the permission of the collector, my lord, and the permission ensures that unnecessarily pain is avoided and the care is taken to ensure that. Now kindly see 3. Notwithstanding anything contained in subsection. I'm sorry, my lord, your lordship.
See, one thing in fact we would like to point out is paragraph 29 and 30 of Nagaraja. The state of Maharashtra issued a corrigendum on 12/9/2011 and later on 24/2012 imposed a total prohibition. Now the state of Maharashtra, the High Court actually upheld that ban.
Yes.
Somebody else challenged it.
Yes.
And then paragraph 30, if you read, we have already indicated that Maharashtra has accepted the judgment of the High Court and the decision. So, unlike in Tamil Nadu, where the cultural and they were siding always with the people there, the government actually imposed a ban.
But the government,
So we are just pointing it out.
yes, yes, but that's never perennial.
Mr. Mehta, that's why this paragraph 25 was a statement of fact by the government of Maharashtra before the court.
Doesn't appear to be, my lord. I'll not join issue.
No,
My lord, your lordships were
There
given
was-
several statements
and
of
there was,
facts, my lord.
you don't know,
You
and
cannot-
there was a complete ban imposed by the state of Maharashtra.
Lord, I do
And
not
that
know
was
whether.
a question raised before the court. Court upheld that ban, review was dismissed, and then the SLP was there. So the government was defending its action of putting a complete ban.
Correct, my
To
lord.
have bullock carts over there.
Correct, my lords, but thereafter, my lord, this new regime, my lord, ban is never perennial.
No, you are asking us
The
that
facts, how it came about.
25 must be a fact which the government of Maharashtra must have put in place before the court.
Yes.
Appears to be subject to what Mr. Mehta has to say.
So where is your law? You want to put this in perspective, how it is done.
Yes, my lord.
Where is the law and what page?
Find here. You have some.
Section 3. But your lordships have not seen the act, my lord. I'm sorry. I went far beyond, my lord, a particular section, my lord. I was also racing with the act. Thinking, my lord, your lordships are with me.
Yes, we have got it. Yes, you can go ahead. You can go ahead.
Lord, kindly come to section 2.
Section.
Yes, this is the amended part. Bullock cart race, your lordship gets one.
Yeah.
Means, and my lord, now kindly forget, my lord, this replaces the ban. Correct, my lord, this replaces the ban. And after, my lord, expert committee going into it and recording a findings which are not under challenge. Bullock cart race means an event involving bulls or bullocks to conduct a race, whether tied to cart with the help of wooden yoke or not, by whatever name called, with or without a cartman, with a view to, please mark, follow tradition and culture on such days and in any district where it is being traditionally held at such places as may be previously approved by the district collector. Well, checks and balances, the safety mechanism inbuilt and also known as Belgada Shariat, Chakdi and Shankarpat in the state of Maharashtra. Now, my lord, section 3. Lord, please see insertion of subsection 2. Notwithstanding anything contained in subsection 1, the bullock cart race may be conducted with the prior permission of the collector, subject to the condition that no pain or suffering as envisaged by or under the act is caused to the animal by any person or persons in charge of the animal used to conduct bullock cart race, and subject to such other conditions as may be prescribed by rules under section 38B by the state government. This is what, my lord, section 11, subsection 3 requires. No pain or suffering, my lord, which is introduced. Now 3, if any person or person in charge of the animals conducts bullock cart race in contravention of the conditions laid down in subsection 2 or rules made thereunder relating to the bullock cart race or causes pain or suffering to the animal, he shall be punished with fine which may extend up to ₹5 lakhs or imprisonment for a term which may extend up to 3 years. Strict punishment and exemplary fine, not just a token fine, to ensure compliance. Then 4, the conduct of bullock cart race in accordance with the provisions of subsection 2 of section 3 or participation therein with a view to follow and promote tradition and culture and ensure preservation of native breeds of bulls, as also their purity, safety, security, and well-being. My lord, there is a breeding, separate breeding takes place, and the breeding bull is also different. Your lordships are aware, my lord. Only pause here for a minute. My lord, the bulls, like horses, have pedigree. The horses, my lord, are also known by the pedigree, that he is son of so-and-so who won Derby, and daughter of son of so, mother is so-and-so who won so-and-so. Look, these are all those category of specialized breed bulls. Now 5, provided that nothing contained in this section shall apply to the conduct of bullock cart race in accordance with the provisions of subsection 2. Then 27 is amended. The conduct of bullock cart race in accordance with the provisions of subsection 2 of section 3 with a view to follow and promote tradition and culture and ensure survival and continuance of native breeds of bulls. Otherwise, my lord, as Mr. Dwivedi said, this breed will die if this is not to be employed in the racing purpose and not nurtured, taken care of, veterinary my lord, care is taken. Then, my lord, the only my lord, destination.
Why do you ban it if it is part of your culture? There's a little contradiction there. If you are part of your culture, would you ban it?
Because there was no provision, my lord, to ensure pain and suffering. Because of the incidental pain and suffering, now, my lord, that is removed. And, my lord, kindly, my lord, at the cost of repetition, mere act of banning once, my lord, may perhaps not weigh with your lordships while deciding an act which takes away the basis of banning also.
Mr. Mehta, the argument was slightly different. The lawyer is not there now who appeared from argument. His argument was, if you see section 3 of the act, it's an unnecessary pain or suffering.
Correct, my lord.
And now you said with the notwithstanding clause of section 2 to section 3, and the term unnecessary is missing. You say no pain and suffering. The word unnecessary in subsection 2
Kindly, my lord.
or in the later part, the hammer in the substantive act is unnecessary, which the Tamil Nadu has taken a brief of the term unnecessary. But the term no, no,
As envisaged by or under the act. No, kindly see the subsequent. Yes, sir.
the lawyer's argument was.
But it's qualified by the subsequent part.
Yeah.
Kindly, for my satisfaction, read it again.
No, we are putting you the lawyer's submission which he made. The
I
legislature in
understand, he makes
Maharashtra
submissions, my lord, but
deliberately deleted this word unnecessary, which is available under the Tamil Nadu.
But your lordships would, my lord, read and decide whether that submission is right. Please read, allow me to read it again, my lord, subsection 2. Notwithstanding anything, my lord, first see, my lord, subsection 3 of the principal act shall be renumbered as subsection 1 thereof and after. So, my lord, this is amendment of the main section. There is no dispute on that. Now, 2, notwithstanding anything contained in subsection 1, the bullock cart race may be conducted with the prior permission of the collector. Please mark, subject to the condition that no pain or suffering as envisaged by or under the act is caused.
What
It
do you
is
say
not
about
in-
11B? What do you say about 11B? How will you ensure that if the bull, if the bull does not want to run the race, it stands there at the start? How do you get it into action? Like,
No,
how do you
11
move it? How do you actually sort of activize it? So some
11B,
section-
my lord,
the section
of the main act.
11B of the main act.
You,
It says that if you cannot employ in any for any purpose, if it is unfit. Because in the case of bull in Tamil Nadu, it's slightly different. Here they are slim. They are actually, they are trimmed up.
That's a different breed.
Breed.
Would your lordships, I am posing a question to myself. Envisage a situation that a horse which is not fit is, my lord, sent for participating in the race.
The race.
Nobody can, that's exactly what this is. A
And
separate breed, separately trained, and people send it to win. We don't send it to lose. So if it doesn't want to participate, it doesn't want to participate.
Provide for it specifically.
So you will not hit it, kick it.
It
none of
cannot
those
be
things
that's
will happen.
prohibited under the rules, my lord.
No, but then does it really work on the ground?
It does.
Secondly, is it
No,
right?
only, allow me to answer this, my lord.
Does it work on
Lord,
the ground? Have
Lord,
you, have you
Lord,
tried
non-
it? Have you videographed it? How the races are run?
Yes, my lord, we have the
Without
videography.
Causing any kind of, pain.
We have the videography, my lord, but if your lordship would like to go through
Because
that
normally,
process.
even in the horse, my other brother was saying, I think you kick the horse. Some
No, my lord, kicking, my lord, every horse needs a little. My lord, therefore, my lord, it is unnecessary pain or something. My lord, when we, my lord, kill, we do, my lord, the people do kill with, my lord, full force. Kick, my lord, in horse racing, my lord, I don't think I need to argue on that.
That's
My lord, that's not, kick is not a cruel kick. It's an indication, a hint that now you have to start. It's like this. Not a punch, my lord. Not a punch. Punch, my lord, causes suffering.
Like our speaker earlier days.
My friend is probably not.
My lord, my learned friend may not do this. My lord, we didn't do this. We didn't do this.
No, I was just saying something in a lighter note when you, anyway, leave it. I thought you still detailed.
Yes. We just wanted to clear the.
You can say.
Oh, that's okay. I don't want to disturb you.
Yeah.
Lord, kindly see the rules. Rules provide for a pre-race checkup by the veterinary doctor. And the collector will give permission only if he is satisfied about full compliance of the rules.
Where do you get the rules?
Yes. Volume 1, my lord, page number 171. Lord, possibly, your lordships are aware, my lord, I need not elaborate on that. Possibility of a breach of law may not be a ground to declare the law to be bad. Then that particular instance needs to be punished. Therefore, the penal provisions that if you don't comply with, then you will be undergoing 3 years imprisonment and 5 lakhs, up to 5 lakhs of fine.
It's a counter affidavit filed by you in the Bombay High Court.
Yes,
Where it was challenged by somebody.
it's
The ban.
it's supporting the ban.
Supporting the ban.
Correct, my lord.
Exactly.
Now, Lord,
What
we
you say there, you might be curious to know what you said there, because sudden somersault.
Because-
That is evident in para 52.
We have not filed
Para
it.
52
Lord,
also
You
this.
read para 52 of Nagaraj.
only a minute, my lord, we thought, my lord, we would be defending the new regime, my lord, so that is not on the court. The old, my lord, affidavit which was filed defending the ban, etc., my lord,
My
was
grandmother wanted you to read para 52.
para 52, my lord, I'll read them. I am obliged, my lord. Jallikattu, as well, your lordship, that para, my lord?
Yes.
Jallikattu as well as bullock cart races, etc., as an event, according to the board, violates section 3, 11(1)(a) and M of the PCA Act, read with Article 51(a)(g) of the Constitution of India. Ministry of Environment and Forest, in exercise of its powers conferred under section 22 of the PCA Act, as already stated, after noticing the stand of the board, issued a notification specifying that bulls shall not be exhibited or trained as performing animals. That position still stands. As on that day, there was a notification of the central government, which is now, my lord, withdrawn long back. MOEF, it is seen, so far as the state of Maharashtra is concerned, is not recognizing that bullock cart race is a part and parcel of tradition of the people of Maharashtra, and that it has cultural, historical, or religious significance. The state of Maharashtra, in its order dated so and so, has clearly acknowledged that organization of animal sports in the state, mainly in its rural hinterland like bull, ox, bullock cart race, etc., is nothing but violence to the dumb animals and has to be prohibited. The state government evidently did not give its stamp of approval to the so-called cultural historical importance to the bullock cart race, and that order has not been challenged. But so far as the state of Tamil Nadu is concerned, now a proposal has been made to exempt bulls participating in Jallikattu, which Maharashtra did, my lord, which is before your lordships.
So you are not anchoring it to cultural thing, but it's on a clean slate, you are introducing a.
No, my lord. No, my lord. The report. Kindly, my lord, now come to the report again, my lord, that it is a part of the culture. The view of the state government earlier. No other matter. Kindly come to, my lord, page 31, the report, my lord. My lord, the government of the day, my lord, whenever they thought, my lord, that this may not be a part of the culture. But ultimately, my lord, how we establish, your lordship's question to Mr. Dwivedi was right, that on what basis you establish that it is a part of the culture and tradition. Some expert committee will have to go into it. The expert committee went into it. And this finding of this expert committee is not a subject matter of challenge. No, before your lordships, it is nobody's case that this is not a part of culture, except, my lord, some old statement made by the state government at the relevant point of time. Please say, my lord, page 31 of the report. Your lordship's
Legal question.
to our advantage, but your lordship's mic is on.
I don't know about my, no, you would have heard what.
No, my lord, not fully. my lord.
Why
Martyred.
this matter has come here? It should have been dealt with by in the Bombay High Court.
I know.
That's what my.
That's what my lord, your lordship was saying, but when I realized that your lordships are audible, I thought it to be my
That's
duty, my
right,
lord, to point out, my lord, that some privileged communication may not be heard. My lord. My lord, there are books, my lord, and I'll place it. I'm not going to read it. In Tamil Nadu, Lord, this tradition is, my lord, thousands of years back. And one of the author of the book is one of the petitioners, I'm told. Lord, it's my lord, nobody's case that it's not a part of culture. It's not a part of, my lord, custom. The only argument, my lord, essentially is that there is some pain, whether you have taken care of it by way of statutory mechanism, and if that is repugnant, whether there is any assent. Assent is also not under challenge. Arguments are essentially based more on compassion than on law. Your lordships are on page 31, or just overleafing, my lord, the findings given that this is a part of the custom and tradition in Maharashtra. And this is, my lord, post Nagaraja judgment and post ban and post, my lord, affidavit filed by one officer that this is not a part of the culture. Look, this dates back to Harappa civilization. My lord, as a matter of fact, my lord, forget the race. The relationship between human and bulls dates back to Harappa civilization.
Suddenly,
Yes, my lord, there is a change of decision, my lord, but in accordance with law.
What we feel is that whatever the amendments are made in the state of Maharashtra, we don't find they were required at all. Because no substantive changes are made except you put the bullock cart as one of the prominents to show that what is the role of why we want bullock cart to be introduced in the state of Maharashtra. What we feel is that in like of Tamil Nadu, whatever the amendments were made, followed with the relevant rules, the same practice was followed in the manner of putting bullock cart in place of Dalikatu, whatever the thing is, in state of Maharashtra, and the corresponding rules were made. Otherwise, you will see back to the amendments in the Maharashtra here, except you put bullock cart as such. What additional you have said? Nothing. The substantive act of 60 remains the same.
No, the distinction is, I can't follow.
This is only because what happened earlier when the matter came to this court, there was a ban first imposed by the central government under 2011 notification, followed by the state government in sequel there to put the ban. That ban was under challenge. So state and the central government were defending their ban under the Act of 60 itself. Now this matter traveled to this court, your affidavits were because of these good reasons we have put a ban. And that was upheld. Para 3025 which you read is in reference to the stand of the state government before this court.
Correct, but
now you made an amendment of 2017 and then you say new regime.
No.
also there they said that it was not part of the culture. There your stand was.
Lord, I can't replace it. No, I can't. I'm sorry. Lord, if your lordship please, Lord, considers that once a ban, even expert committee cannot be relied upon, my lord, matter ends. There was a ban, some officer did say it's not a part of the culture. Thereafter, a committee is appointed. I'm trying to show to your lordships the committee report on my lord, how it is part of tradition and culture.
Give us the rules. Give us the rules.
My lord, kindly allow me, my lord, to show, my lord, how it is a bald assertion vis-a-vis, my lord, subsequent going into the facts.
Where are the rules?
Yes.
Page 151.
Page 170.
151 it is there.
170, my lord, of
Volume 1.
Compilation document, convenience
Page
compilation.
170.
170,
7.
170.
Page 157. Yes,
One
same
seventy.
page 157.
सवाल ही सारे.
This, this photograph showing.
Oh, your lordships are on the report. I'm sorry. I thought I was on route.
We'll go through the rules, but he just wanted an essay.
Yes.
This is a photograph at page 32,
Yes.
where it is now pictured, picturized as part of bull racing.
Yes.
Isn't it not really an act of the farmer carrying out plowing?
Can be.
Huh?
This is to justify, my lord, the cart.
That's right. But what the report says, it is a bull racing.
My lord, let
I
me
will-
read the report, my lord, and if your lordships would like to, my lord, declare that this report is possibly
This report, we
inadequate.
are only asking you
Yes, my lord.
that we thought that, you would have seen how the farmers, they plow. They will also have a stick or whatever they have.
They should stop now.
Just stop. So this particular photograph, you're just saying, it has been associated with bull racing. What you're saying is it looks more like plowing.
Lord, if my lord, we have to take a second look and second view, Lord, possibly that can be taken. My lord.
That's right. No, the point is what we are concerned is, how does the state at one point of time assiduously ban and vigorously defend the ban, saying it is not part of the culture? Then suddenly one side body, not with
Lord,
too
that-
remote, suddenly say, no, it's part of the culture. We can't take
I'm
that.
sorry, my lord. I'm sorry, my
Tamil
lord.
Nadu is very consistent. Tamil Nadu is throughout held it is part of the culture.
Lord, only thing,
In the review petition, they argued it is part of religion. Please appreciate.
Culture, it is.
So written at 25 and 29, there's a difference.
We can't draw lines in that.
my lord, the only distinction between the earlier stand and the present stand is the committee report, reconsideration by the government, and my lord, it is the entitlement, my lord, of the government to reconsider its decision based upon, my lord, the report of the expert committee.
Yeah.
But that's, my lord, I don't think, my lord, would be a disputed proposition as a law. Now, my lord, I am coming to the question of assent.
Yes.
Lord, please note, there is no challenge to the assent. After, my lord, your lordship's query on the last occasion, they have suddenly, my lord, given some draft amendments, and I would request your lordships not to entertain a challenge to the assent, because there was none, and it cannot be made at the last minute without my pleadings being on record.
Yeah.
So far as the files are concerned,
Yes, please go ahead. Now, what is the assent part?
yes, Lord, at the outset, straight, my files are here and I'll give it to your lordships. There is no difficulty at all. Now, Lord, allow me to say something as a proposition of law. Lord, the files may be given first.
And just give it so that, in the meantime, we'll see it and then.
No, Lord, that's the problem, Lord. I would wish your lordships to hear me also.
That's right, we
Yes.
hear you.
Not in the meanwhile, your lordship may do it after.
Once you go away, we can't ask you anything.
No, Lord,
We need to get you here.
on the lighter side,
In
Lord.
life and life.
Please don't go through it while I'm arguing. That's all I say, Lord, on the lighter side.
Otherwise, we'll not be in a.
But-
position to ask you.
Yes, my lord, now I'm, my lord, submitting the written.
There's nothing, it'll be there, the assent, everything will be there, I think.
It is there, my lord. But, my lord, it is only, my lord, for your lordship's perusal.
Correct.
Any documents, my lord, these are all constitutional decisions signed by the President of India. My lord, I would not wish anybody else to see it. There is nothing confidential about it, but there is a sanctity about it. That's all. Now, my lord, kindly, my lord, see, my lord, this is my written submissions. I want to read one judgment. And your lordships may, my lord, kindly thereafter. And this law, my lord, stands today. It has held the field, my lord, and is a good law. Well, just to assist your lordships, my lord, what would be the parameters within which your lordships would also be looking at the file? My lord, ultimately, your lordship knows, my lord, the presidential assent has its own constitutional sanctity, not that it's not subject matter of a review, etc. I'm not pitching that high, but the parameters would be, my lord, the threshold would be very, very, my lord, high. Kindly come to page 21, right side bottom is the pagination.
Yes, we got it.
Yes, my lord. This is, my lord, Cassere Hind, Lord, the landmark judgment, my lord, which deals with this.
That's right, that's right.
In the efforts.
Morning we were taken through para 20, 25. So
Yes.
we can avoid reading it because we have read that.
Yes, my lord. Kindly, my lord, come to 25, my lord, once again, my lord, for this purpose, assent, for the purpose of assent, my lord. In our view, for finding out whether the assent was given qua the repugnancy between the state legislation and earlier law made by the parliament, there is no question of deciding validity of such assent, nor the assent is subjected to any judicial review. Here also, there is no challenge to that. That is to say, merely looking at the record for which the assent was sought would not mean that the court is deciding whether the assent is rightly, wrongly, or erroneously granted. The consideration by the court is limited to the extent that whether the state has sought assent qua particular earlier law or laws made by parliament prevailing in the state, or it has sought general assent. In such a case, the court is not required to decide the validity of the assent granted by the president.
That's right.
In the present case, the assent was given, etc. Then 65.2. Article 254.2 contemplates. Lord, kindly, my lord, see para 27 of, my lord. It's not quoted here, my lord, but it's, my lord, I have given, my lord, that's, my lord, something relevant, my lord. My lord, it's crystallized for your lordship's assistance in the judgment.
So we are listening. 2002. We have noted it.
Would your lordships like to, my lord, listen to it? My lord, I'll just read. Para 27. In this case, we have made it clear that we are not considering the question that the assent of the president was rightly or wrongly given. We are also not considering the question that whether assent given without considering the extent and nature of repugnancy should be taken as no assent at all. Further, in the aforesaid case, before Madras High Court, also the relevant proposal made by the state was produced. The court had specifically arrived at a conclusion that Exhibit P12 shows that Section 10 of the Act has been referred to as the provision which can be said to be repugnant to the provisions of the code and the Transfer of Property Act, which are so and so. Now, last paragraph, Lord, unnumbered para. In any case, does my lord say, Lord? In any case,
Which paragraph?
as Lord, same paragraph, last 4-5 lines, my lord. After before one, my lord, before bracket 1. In any case, my lord, classitum D. In any case, as discussed above, the essential ingredients of Article 254.2 are 1. Mentioning of the entry or entries with respect to one of the matters enumerated in the concurrent list. 2. Stating repugnancy to the provision of an earlier law made by Parliament and the state law and reasons having such law. 3. Thereafter, it is required to be reserved for consideration of the President. And 4. Receipt of assent of the President. Now, para 30, next page. Finally, we would observe that challenge of this nature could be avoided if at the commencement of the Act it is stated that Act has received the assent with regard to the repugnancy between the state law and specified central law or laws. Because the legislature, whenever mentions something, it is treated to be sacrosanct unless established to be factually incorrect. Here, my lord, all the three legislations mentioned, all the three, my lord, acts mentioned in the statement of objects and reasons that it was reserved for the Honorable President and referred for the presidential assent, and the President has granted the assent. And in any case, my lord, grant of assent is not in question. This is only, my lord, respecting, my lord, your lordship's word that my files are here, and my lord, I will submit it for your lordship's perusal. There is nothing to hide from the court. But my only worry is, my lord, that this may not become a precedent, that in every case the files which are ultimately signed by the President, my lord, are called for and, my lord, are subjected to scrutiny. But your lordships can definitely look into it. But all the three acts, my lord, all the three files are here. They are original, my lords. My lords,
Karnataka,
Tamil Nadu and Maharashtra.
That's right. We'll just go through.
Lord, your lordships can, my lord, retain it and can return it subsequently also, but there is no difficulty.
Yeah.
Because multiple ministries are involved, their opinions are taken. Once in one of the matters, the opinion of the then Lord Law Officer, the learned attorney is taken. And my lord, it's thereafter, my lord, the Honorable President, my lord, one there are two presidents, my lord, because of the time gap, and all the three are signed by the Honorable President. Lord, I would only make one request. Lord, because of Lord respecting the lordships, my lord, desire, my lord, to peruse the file, Lord, we have given this. And we don't record this in the order so that it doesn't become a precedent. Your lordships are in a file judgment. I'm sorry, my lord. Lord, my respectful request is this. Lord, Lord, there is an earnest request. Can consider
Attention. Otherwise, we would not. Para 20. You drew our attention, para 27.
correct.
And towards the end of that para, it is said, we do not think that in any case as discussed above, the essential ingredients are mentioning of the entries with respect to any of the
Yes, I've read that. I've read.
Then you said, stating the repugnancy to the provisions of an earlier law made by Parliament and the state law and the reasons for having made the law, thereafter it is reserved for the President and then. So we are only taken up with the first two.
Lord, I know, my lord, I am before
Stating the repugnancy.
I am before the Constitution bench, and your lordship knows, my lord, this is not the statute we are reading. We are reading the judgment, and your lordship knows the ratio, my lord.
So the ratio is in this manner.
Lord, your lordships can, my lord, have the files, but allow me, my lord, to make my request, my lord. I am trying this, my lord.
Yeah.
Yes, my lord.
Your request
Lord,
is.
please do not record that the files were perused. But your lordships are in a Constitution bench combination. Lord, this becomes a precedent, and that worries all of us, my lord, as officers of the court. That decision taken by the president was looked at and was reviewed judicially in absence of the challenge also. Now, that's my worry, and therefore, my lord, please do not undertake, my lord, that course of action.
The president assent is being called, we wanted your enlightenment so that you can tell us. That the president's assent is called in question. It's really not an assault on the kind of dignity of the high office of the presidency at all involved. In a country which is governed by the rule of law and by a written constitution, we were just wondering what response you will have. You will certainly have a
I
response.
would not rather give the response. Your lordship knows the law on the point.
No, the point is only this.
There is no question of lowering the dignity. There is a question of constitutional sacrosanct,
So it is
constitutional.
never meant as an assault against the presidency or against.
No, it is considered if it goes, my lord. Anyway, my lord, I will not.
There's no challenge. There's no.
My lord, it would. I'm my lord. I'm my lord.
77 is quoted in Kedri, which is very clear.
My lord, only one thing, my lord. My learned senior is right. Even if there is a challenge, your lordships will have to prima facie be satisfied that the assent is bad, and then only the files are called. My lord, not, my lord, I'm sorry for using this, my lord, but not to satisfy intellectual curiosity. My lord, these are all constitutional sacred things, my lord.
Foundation should be there. The-
Yes, factual foundation, challenge, and the prima facie case, so that your lordships can examine.
I wonder which.
I'm not taking this, my lord, as an ego battle.
We only want one thing to know. Under which ministry does prevention of cruelty to animals fall actually? Just we want to get into this.
At that time, there was Ministry of Environment and Forest. Now there is a separate ministry.
At that time, it was dealt with by the Ministry of Environment.
Environment.
We just wanted to know that.
Yes. It's there in the file, my lord. At the relevant point of time, it was MOEF whose opinion was taken. And my lord, this ministry which deals with the Honorable President is the Ministry of Home Affairs. The my lord, aid and advice of the Honorable Home Minister is also there. My lord, there is a
No, we want to know. Market also.
the law.
We are.
Just factual thing. One factual thing.
Only a minute. We are
No,
not
one
on.
minute.
We are not on factual. We are on constitutional.
Please.
Lord, we are traveling, my lord, an area which the lordships may avoid.
Lord,
Lord, please do not do this.
Lord, only this one, just one. Lord, I just want to clarify one thing.
Just a moment.
That where is the challenge?
Yes, I am showing that because I only added.
And the foundation.
There is a foundation. I want to show that because your lordship didn't take the amendment. The amendment only adds one particular thing, but the foundation is there. Somebody should read it. But the point.
Lord, unless the prima facie case
Yeah, I'm
of
saying that there is a foundation in ground. You may just read that because your lordships are told repeatedly there is no foundation. Let me just read that.
Look, can I?
Yes, please, Mr. Then you can answer your point. In Kesara Hind versus so and so, this honorable court held that there can be no concept of general presidential assent, that the president ought to be properly informed of the possibility of repugnancy and the extent of the same.
Lord, say something, my lord, I can say
I'm
something.
just actually correcting you that there is.
Lordships are sitting in appeal over the. My lord,
I think, we are not sitting in appeal. We like.
Lord, I want.
Can your lordships allow me, my lord, 2 minutes?
Please, yeah.
The page from which he is reading is given on 28th November during the midst of the hearing.
No, I am on a different point.
He
Ground.
is reading this ground, my lord, which is
Just
kindly.
allow me because I don't want to be told again, don't argue. ground Q makes out the factual foundation.
In the midst of the argument,
No,
only
please,
because my lord
not
Justice
given
Joseph,
enough
my lord,
time to-
inquired from me, my lord, they
No,
are now
just see
coming out with the ground.
Unfortunately, my lord, lordship that day said, please stop. I stopped.
Lord, it would not be fair to me, my lord, that's all I have to say.
I only want to read ground Q, which is the factual foundation.
Just tell us the ground, that's all.
Ground Q.
And
All
the date on which it is raised.
All-
And the date on which it is
all
raised.
the three writ petitions by FIAPO, ground Q.
Okay.
This is 28th of November 20. Advice given by the Council of Ministers, which is constitutionally prohibited from court's examination. Lord, I am avoiding going into, my lord, an area, my lord. I merely respected your lordship's word and place it for your lordship's
You
consideration.
see, when the files are there, you are well aware of the law. It is only the advice per se. Advice per se.
But your lordship's mic is not on.
It is the advice per se. It is not the entire cabinet papers, which, as you know the law, I think we don't have to tell you what the law
Lord, your lordship also knows the law, my lord, on this subject, my lord. I am saying something else. Lord, Lord, if your lordship would like to, my lord, consider.
I am only on that. My worry is only that. what is troubling us is only one aspect. And our problem is whether putting that question to you will sort of be a constitutional sort of heresy. To sort of ask you that question and elicit an answer will involve disclosure of things which.
It
that's-
would, my lord, and it should be avoided. And one more thing, my lord, with profound respect, Lord, whenever a constitutional decision is not even in question, I hypothetically assume it is in question, what will be the procedure, the rule of law which your lordship said would follow? A factual foundation that this is bad for ABCD reasons. Your lordship's prima facie satisfaction that yes, it appears to be bad for ABCD reasons. It is only thereafter that the court would call for the files. I suggest, Lord, Lord, I would wish to, my lord, address your lordships on this question, Lord, in absence of any challenge, suo moto, whether your lordships, Lord, would be.
Sumoto will not do it, but there is a challenge. There is a challenge.
Lord, I have repeatedly said, possibly I missed your lordship's attention, that that challenge was after your lordships indicated on 28th of November. I would like to file my reply, my lord, and address your lordships on the contours of the jurisdiction.
It was not there earlier, prior to that.
Not the original petition filed 5 years ago has that pleading. In the amendment, I only added one sentence. If your lordship doesn't want to allow the amendment, it's okay. But ground Q makes it very clear, my lord. I'll read it out because my learned friend possibly may not have read it. It says in Kesar Hind, etc., this honorable court held that there cannot be no concept of general presidential assent, that the president ought to be properly informed of the possibility of repugnancy and the extent of the same when seeking his assent in the passing of the ordinance. Therefore, it is clear that if the repugnancy contained in the act was not communicated clearly to the honorable president, it is open to the courts to interpret whether the due process has been followed. So the factual foundation is there. No, but somebody has to.
There,
No, there is not a factual.
there is no
foundation.
factual, this is just
I'm
a
saying-
bald assertion, my lord.
This is a
Make
statement
it
of the
un-
law. It's a
No,
statement
please,
of
let me
the factual
finish.
foundation.
But this is not fair. Right through, it's always
No, this
interruptions.
is not,
I have not interrupted anybody. Lord,
You are
even when, no, I'm sorry, Mr. Sibal, don't say that.
Yeah.
We don't have the information about the president's assent. How can
Lord,
these
your
things
lordship,
go
your
not
lordships, my lord,
We can only
here are-
speculate. We can only speculate.
would your
We
lordship,
have speculated and we say it's open to your lordship to interpret it. I'm not even asking. My lord.
speculation is not a ground, my lord, to make out a challenge. There is no challenge. They have made a statement of law in ground Q. That this should be, in absence of this, it cannot be, that's all. If your lordship.
Yes.
Lord, then, my lord, your lordships, may, my lord, we would address your lordships on this. Lord, your lordships may, my lord, allow us to have, my lord, the arguments on, sorry.
Do you want us to speak our mind? Do you want us to ask questions? Or do you think that
Your lordship's mic
we
is
should
not
not
on.
go into,
Mic.
sorry, the mic. Do you want us to ask you what is troubling us? Or will you, sort of shelter under the advice theory that you can't go behind it? In which case we'll say,
Your lordship will say anything.
what you're saying, there is something which we found there, which troubles us. In keeping with the law which you laid down, I mean, which you drew our attention. We are grateful to you because nobody read that portion.
I'm grateful, my lord.
We are really grateful because none of them actually brought that to our notice. That last part of para 27. The ones that is brought to our notice, what we saw is what troubles us, so that we keep.
But I would like to address your lordships whether the file can be gone into in absence of, Lord, any factual foundation being laid. I'm not concerned with this case. I'm concerned with, my lord, the rule of law being prevailed, my lord, on both sides.
Yeah.
And, my lord, then kindly, my lord, have it, my lord, we'll address your lordships on the question of contours of this jurisdiction. I thought your lordship would like to just peruse, my lord, and I have, in good faith, my lord, given that there is nothing to hide. Henceforth, we'll be careful.
Argument. If you have concluded, we'll postpone.
These are my submissions.
These are your submissions.
And if your lordships are going to, my lord, examine this, I would earnestly request, my lord, to allow all of us, my lord, to address on the question of contours of court's jurisdiction.
All right.
It was, Lord, by way of, my lord, profound respect that your lordship's wish was, my lord, fulfilled, without, my lord, going into that question. But
Mr. Mehta, do one thing, give it a short brief in writing also.
no, my lord, on that, my lord, we would all like to address your lordship. My lord, if it is,
Give it in writing to us.
no, my lord.
Whatever judgments you want to rely
No,
on.
no, my lord. In absence of a challenge, my lord, in absence of a challenge, we would like to address your lordship on this question.
Lord, I'm sorry to say, but there is a challenge. I
There is
cannot
no,
understand.
please see the,
Maybe
show the
my
player.
understanding of English is all wrong, but in my respectful submission, there's sufficient ground of a challenge. Please
No.
read ground Q in all the petitions.
We also have a different understanding.
Yes,
As we have learned,
my lords.
grounds, if you see the affidavit, grounds are advised by the lawyers.
Yes, but how do we,
But the factual foundation is by the person who plead.
correct, now
And
let's,
the person who plead is the petitioner.
yes,
So it is his pleading which is supported by the assistance of the lawyer in framing the grounds. That's what we have learned about it.
no,
That according to us is the pleading.
fair enough.
God knows what kind of
No,
pleadings are.
maybe, my lord,
As we have learned, this is the pleading system.
Lord, please,
Yeah,
Lord,
obviously.
I assume, Lord, your lordship.
no
are
prayer, no
absolutely
prayer,
right.
my
Facts are pleaded before the grounds. Grounds are just relating to the, now, Lord, in this case, when the assent and the papers are not even available in court, how do I make a factual foundation
Well,
except
this is not-
speculate? How can I say, no, it's not there? I have to speculate.
So that, you mean to say that in all cases where assent is there,
Who is arguing?
you need only to make a general
No, I will
statement
say,
and then
no,
ask
I
production of
say, this is the law, in this case is not followed, that's all I'm saying.
If you leave it to us, we will.
Very well, no, because my learned friend is saying, that's all. We have actually asked for the documents, they have not given them.
But you did not challenge it.
Lord, please see ground Q, my lord, please see ground Q.
Have you amended the prayer?
No, I have actually taken a ground Q to challenge the act. I don't have to make a,
ground has no.
why should I make a
factual
prayer?
It's a legal submission.
Yeah.
based
Yes,
on
I
lawyer's
can. Why
advice,
can't I?
that's all.
Prayer is to strike down the law. I can't say no, prayer, give me this. Grounds are necessarily the basis for a challenge to the act.
Assent is based on a constitutional procedure. The challenge.
I have
has
also
to be
asked them to
that
produce the
a
document.
particular procedure has not been followed, therefore the assent of the.
That's what it
president
is,
bad.
ground Q.
You said, I do not know, it's speculative, I want to find out whether it's bad or not. You can't do that.
Why not?
For distinguish, because you do not know what the procedure is and you are challenging it, and challenge is speculative.
Not
There is no
speculative.
factual foundation for your challenge.
You know you haven't
This is
followed,
a
you don't want to
serious
disclose it.
Challenge.
There is
You
no
know you
challenge
don't
at
follow,
all.
you don't disclose it.
You know,
It's clear in ground Q.
every presidential consent will be challenged that this is bad and therefore the file should be shown.
It says that they have.
What kind of legal argument is that?
Let us go through the file, we'll make up our capable of taking.
So just see para 77 of case again also.
No, we want, who's arguing next?
What, Mr.
I just want to
Unlike-
complete one thing on Maharashtra, my lord. On the change of the stand of the state, because it was said that earlier in 2011, we had a particular stand. Can I just complete the factual narration there? Because I have something to show there.
What more, it's already 3:30.
It'll-
We can't go on.
It'll only take me 5 minutes to place it that we've not changed our stand.
Give me the written note.
My lord, can I-
Written note.
Written note, there's no need to.
No,
ask
I
it
just,
again.
no, I'm giving my written note right away.
That's the way, that's.
I won't even read it. Let me just point out what it was. Can I just tell your lordship what it was? It'll just take me a minute. In 2011,
Yes.
well, I'm just telling your lordships, I'll put it in a drop. Now, my lord, your lordships in Nagaraj showed para 25, rather saw para 25 to 29.
Hold on.
We'll go through the file. I don't think the problem, when we see the file in greater detail, the problem is the issue which we raised may not be there.
That's right. That's what I thought.
We will let us go through it.
Yes.
Please.
My lord, this is what I was saying. Sorry, your lordship.
Doesn't have this.
No.
Complete whatever.
All I was saying was, my lord, your lordship saw in Nagaraj, there was a 11/7/2011 notification, followed by a 1/8/2011 notification of the state of Maharashtra. Just hand over my submission. I'm not placing those submissions. Now, thereafter, what happened was, my lord, the state of Maharashtra, para 29, it is mentioned, of Nagaraj, issued a corrigendum dated 12/9/11, clarifying the difference between a castrated and a non-castrated bull and permitting castrated bulls to race. Now that was challenged before the Bombay High Court, and the Bombay High Court passed a judgment saying all bulls should be treated equally and they should be banned totally, and that the state was directed to notify. Therefore, my lords, this 20th/4/2012 notification came. Now the matter travelled to your lordships court, Supreme Court, and on 15 February 13, the state said, no, we don't want the ban. Therefore, with conditions in the order, the ban was overturned and racing was allowed to go on.
Yes.
That is what I wanted to tell your lordship, that therefore the state of Maharashtra has never changed its status. Those orders, my lord, your lordships will find in Maharashtra's volume 6 compilation at page 4 to 7 and 12 to say that Maharashtra had always taken a consistent stand. It's not that we said at one point there should be no racing and later that there should be racing. I've also given a more comprehensive note, but on this, please permit me to give 2 pages.
Yes.
All right, oblige.
Yes.
Lord, I have 2 submissions to make. One is, my lord, in
Yes, please go ahead, please go ahead.
Lord, I have 2 submissions to make
You are appearing for?
for my lord Tamil Nadu.
Oh, Tamil Nadu.
But Lord, I will not talk about what has been argued. I have 2 submissions to make. One is in respect of Nagaraj, and one is in respect of the current scenario.
That's
In regard to Nagaraj, is my submission that Nagaraj, my lord, does not lay down correct law. There are several petitions, my lord. So I want to make a completely different line. Lord, I am making a completely different argument. And Lord, I will make it very briefly, Lord, as
Yes.
short as possible.
As
My submission is that Nagaraj is incorrectly decided.
Oh,
And Nagaraj, my lord, is the basis for this petition before your lordship, primarily. Now, Nagaraj, my lord, has 3 pillars. One, repugnancy. One, the 3 reports of the board showing the prevailing position then. And the third, that animals have statutory rights which have been raised virtually, my lord, to constitutional rights. So these 3 pillars, my lord, of Nagaraj, in regard to 2, my lord, namely repugnancy and the scenario. Repugnancy, my lord, is met by virtue of assent, and the scenario then prevailing is taken over by the scenario now prevailing, which is based, my lord, on the rules which your lordship saw, and the stand of the board now in writing that for the years 18, 19, 20, 21, they have used this plot. The board now says for the years 18, 19, 20, 21 and 22, there is a sea change in the scenario, and by virtue of the rules which are being strictly implemented by the state of Tamil Nadu, the position then obtaining does not obtain today. That's what they say. So we are left, Lord, in my respectful submission, with the issue of rights, Lord, of animals. And I respectfully submit, Lord, and I'll show you some passages, that the judgment proceeds on the premise that they have rights, animals have rights, because humans have duties. If humans have duties, animals have rights. Lord, I'm only paraphrasing it for shortage of time. This is what the judgment says. Because humans have duties, including the phrase humanism in
speciesism.
speciesism and humanism, both belong. In 51A, G and that provision belong of duties. So if humans belong have duties, animals have rights. And those rights are under 3 and 11. And they have to be protected, which means, my lord, that they could be statutally enforced. If you have a right, you have a right to enforce it. Otherwise, what's the right? This is the basis, Lord, of that judgment. I respectfully submit, my lord, there is no warrant either in our constitution or, my lord, in this act to say that, my lord, the duties on humans leads to a corresponding rights of animals. And those rights, my lord, if I may say so, the rights, my lord, under this act have been intermingled by the judgment to rights, my lord, flowing from 51A and my lord, the 5 freedoms of an international organization, 5 freedoms, 51A and 3 and 11 have been, my lord, mixed up to say that this is the compendium of rights in the judgment. I respectfully submit, my lord, there is no warrant in our constitution. And if I may say so, my lord, the judgment at one point pitches it at Article 21. But when it comes to directions, my lord, it recognizes that it is not 21, but it should be elevated to 21 by Parliament. That's what, my lord, the compendium is. I submit, my lord, there is no warrant. Kindly, my lord, have a look at the act for a second and then, my lord, the judgment. My lord, your lordship will find, my lord, your lordship has read 3 many times. I don't want to read it again. It talks about, my lord, unnecessary pain, etc.
Yeah.
Now, my lord, the judgment starts by saying that if you have a duty, a human has a duty. Otherwise, what I'm trying to drive at is, my lord, the duties and rights are between humans. That is morals, ethics of a society. 11 is nothing but morals and ethics of a society. You will not behave in this fashion. You will not do like this. You know, even in humans, there has to be orderly conduct in a community. You will not kill somebody, you will not rob somebody. Those are our morals. Law is nothing but, my lord, a compendium of this
They
law.
may not be ethics, but they actually constitute the ingredients of an offense.
Correct. I'm very grateful. So, my lord, these are morals which, my lord, people must adhere to on the,
Not morals. It is a legal duty, as you correctly
or a legal duty on the pain of sanction. My lord is right, on the pain of sanction. If you don't do this, you will be disorderly.
That's what we pointed out, salmon. We pointed
Correct.
out
Correct.
salmon.
My lord, the salmon is referred to, my lord, in the judgment. If your lordship will have a look, my lord, the judgment starts by saying, and if I may say so, my lord, without any precedent. There is no precedent that 3 provides for rights of animals and therefore there's a duty on humans. You are, my lord, putting the so-called rights of animals with a corresponding, my lord, or a duty on humans with a corresponding right of animals. There is no warrant. It is not prescribed anywhere, not in our constitution.
Can an animal
Yes.
possess rights, legal rights?
Correct. Very. My submission is, my lord, no.
No circumstances.
No. In our constitution. In some constitutions in the world or some, my lord, agreements in the world, people have recognized it there.
Does entry 97 of list 1, which is a residuary list for parliament,
Yes.
clothe the parliament with regard to legislative power to make laws in
Yes.
respect of matters which are not found
Of
specific?
course it can. Of course.
So can animals, we are again asking you, be the subject matter of
It can if Parliament so decides. No doubt. But Parliament has not decided. Parliament has not decided either by this law, my lord, or by the Constitution. And importing,
Parliament can create legal
of course, Parliament can, no doubt about it. And my lord, your lordship, remember, there is a word of advice in the last portion of Nagaraj that we expect Parliament to be allowed to do this anyway. No problem. Like the Lordships have said, Parliament may not. There can't be a mandamus to Parliament to do this, that, and the other, but that, we were not on that field. I am only saying, at the start of this judgment is that 3, which is an injunct, really speaking, or a human being. It's an injunct by society which is represented by Parliament. That look, when you exist in nature in this world, this is how you will behave. And if you don't, as my Lord rightly said, it will be on pain of sanction. But that does not mean that a human being, by virtue of this injunct or duty or morals or duty, whatever you call it, will give a corresponding spring, a corresponding right in an animal. Otherwise, the law would have indicated so. Contrast it now. Fundamental duties and directive principles are not enforceable in a court. They exist for humans. They exist for citizens. So even citizens in this country cannot enforce fundamental duties or directive principles against the state. Because Lordship knows, I don't need to read them, from 39 downwards, adequate livelihood, adequate health, adequate this, that, you can't have. You strive for an ideal world, but it cannot be enforced. If a fundamental duty or a directive principle cannot be enforced, and it is elementary, settled law, you can give lots of judgments, but Lord knows it better than I do. If fundamental duties, and directive principles cannot be enforced by humans against humans or a state, which a state is also a body of humans. If that cannot be enforced, how is it that the rights are contemplated of animals which are intermingled and interspersed with fundamental duties under 51A? That's what has happened here. If I may say so, the judgment is overbroad. It forgets the distinction between rights and duties. There is no such thing as between men or humans and animals. And it just proceeds on that. There is no precedent in Indian law or the Constitution. That's how it is proceeded. No, have a look at 11 for a second. See 11, See, So this is an injunct on the human. Don't do this, don't do this, don't do this, don't do this. If you do this, sanction of law in 11. Have a look. If any person beats, kicks, overdrives, employs, etc., or causes unnecessary pain, etc. But keep going further. Keep going further. See, C. Willfully and unreasonably administers. See, F. Keeps for an unreasonable time an animal chained. How are we going to be enforced?
They are ingredients of offences.
No,
they are really ingredients of offences because shall be punishable.
I'm going to read that. I'm only trying to say, an animal can't come forward and say that I'm being unreasonably chained. But Lordship is perfectly right that it is, an injunct on you. If you do this, you will be punished. No problem.
Somebody on behalf of the animal can come.
With great respect. That presupposes the point that the animal can go to court.
No.
It's like an attorney or somebody else.
We are putting it in a different way.
Yes.
That just because the animal cannot go to court itself for himself or herself.
I appreciate. I am only saying, there must be a foundation in the law or the Constitution to say.
On that we have.
Yes.
Are you saying that the animals are they are not having any enforceable right, and therefore somebody cannot come forward to enforce it?
Right.
When they are not having any.
No, I'm saying they don't have any right.
That is what I.
Enforceability is a second. They have no right.
Because you said that the fundamental duties and directive principle, even the human beings cannot enforce.
My Lord, I'm grateful. That's why I'm drawing.
That is
I drew that. Yes, you're right. I drew that example because this judgment has intermingled fundamental duties into this 3 and 11. There is no basis.
give you two examples, two further examples,
Right.
which perhaps take your argument forward a little.
I'm grateful.
There are laws which prevent, cutting of trees.
Correct.
Trees have life.
Yes.
They also have life.
Correct.
Can it be said that trees have rights?
This, my lord, I was going to say that.
Take, for example,
You had the Chipko movement
take water.
4 years ago, my lord.
You take
Yes, your lordship is right, no?
supposing the effluents can't be, put into, ocean or whatever it is. Will the ocean, will nature have rights?
Correct.
Is it, or is it an ingredient of an offense?
It's ingredient of an offense. You spoil environment, sanction of law. Spoil an ocean, sanction of law. Otherwise, my lord, it'll be an anathema to our, the way we think. It's all humans. This is how it is. Humans have to live in an orderly form, which is the society. These are rules. As my lord rightly said, you spoil this, you'll face sanction. You do this, you'll face sanction. There is no right in that tree or grass or a vegetable that you are cutting it, my lord, in a particular time. You can't do that. The judgment will not be great respect. Call it per incurium, call it sub silentio. I don't want to get involved in that debate, my lord. There's not much time. But when you start on first principle and say that 3 and 11 is a statutory right and therefore a duty on my lord an individual, that, my lord, with respect, my lord, is not palatable. I want to show you one more thing. My lord, recall the earlier part of this discussion. There was a lot of discussion in the judgment about amusement. Nagaraj only talks about amusement, my lord. Doesn't talk about, my lord, culture, tradition, whatever. It says for your own amusement, you are doing this, that, or the other, which is not permitted. And we are saying, my lord, it's not amusement, it's culture, breed, all that, my lord, I'm not repeating. But I want your lordship to have a look, my lord, at, my lord, this M, subclause M, 11M, my lord. I just read M.
Yeah.
So, my lord, 11 will start one by saying, if any person, then we go to M. Solely with a view to providing entertainment. If he confines or does this, that, or the other, or to incites or fights, etc., then, my lord, he will be punished. So, my lord, the offense is, you can have, my lord, sole amusement, but if amusement leads to subclause 1 and 2, then you will be punished. Take an example, my lord, of horse. I have a horse. I use it for riding. Not as a beast of burden. Not as, my lord, for agriculture purposes. Not like a donkey, not like a camel. I use a horse only for riding. That is pure, my lord, amusement. So pure amusement is allowed in M. Even if Jallikattu was to be pure amusement, without, my lord, falling in the clutches of these offenses, CM, my lord.
Yeah.
Solely with a view to providing entertainment, if he does this, that, or the other, my lord, he will be guilty. So, solely amusement, for sole purposes of amusement, is permissible.
No.
Kindly have a look. I'll read it.
If any person solely with a view to providing entertainment
Yes.
does any of those things,
Correct?
then it's an offense.
I agree. But if he doesn't do all those things,
If he doesn't do it, of course it doesn't.
correct, my lord. All I'm saying is, what I was trying to drive at is,
Mr.
if I keep a horse only for riding,
Mr. Rogi, just to test the proposition that you are projecting before us. You are saying that Nagaraja,
Next one. So
it
no,
talks about
to make it object of prayer for any other animal, then and then only it will.
well,
So confining by itself will.
Then you have to meet also 11B.
But this one,
You see, it is like the sort of the other newspaper case. If you come to 11B, but
yes,
and you see,
Yes.
each of these clauses, duties are separate and mutually exclusive.
yes,
You take just read clause B.
yes, ma'am. If any person employs in any work or labor or for any purpose,
All for any purpose. We are already concerned with that.
any animal, which by reason,
We can
that is
skip all
not
that.
a
Skip all that.
purpose other than work or labor.
Skip all that or other cause. Or other, see, we only want you to read
Or other cause, yes.
employs any animal for any
By,
purpose.
by,
if for any other cause is unfit to be so employed.
Yes.
So here what Nagaraja argues is that the animal in question, the bull, is not suited. This is the thing.
That's yet another issue, Milord. That's yet another issue. That Milord specific type in the Maharashtra report, Milord, it is replete with this. That certain bulls and certain breeds can run and are meant to run, but are not meant to, Milord, wear the plow with maybe 50 kilos and do agriculture. While generally they are, and they would do that. Like an Arabian steed, Milord, would run, but would not drive a horse carriage. Things like that.
What is your answer to the argument? Because that's perhaps was the most central point going to be that when you let a bull into, in a Tamil Nadu situation, surrounded by 13, 14 men, as they have now made, because if they participate, they have made
Yes, sir, correct.
not one, many will surround.
Yes.
So the bull is traumatized. Past experiences has taught it a little bit. This is what I'm going to expect. So in whatever little limited brain the animal has, it starts working, the chemical starts working. And the emotion of fear, this
That's what the judgment says.
Nagaraj argues
Yes.
that fear is equal to pain. You put it like this, fear is equal to pain. Now the pain not relatable to any essential activity of the human being, as compared with, as captured in 11.3 A to E. All are needed. This is again, like you said, for entertainment, that is not prohibit what you say.
If you don't violate those subclauses.
So here, if it is not really suited, like for example, you are doing with the horse. Like we play with our horse, with our pet dog. We do a lot of things with it.
Yes, sir.
But you stop where you cause pain to it.
Yes.
That is the central point, that fear. Nothing remains. We agree with you that after the rules, if the rules are properly implemented, the factual matrix of
that time will go away.
Knocked out. You're right there. We'll proceed with that. But then what happens even now?
With great respect.
What is your answer?
Your answer is this. That is what the court found 8 years ago. And the last 4 years of 18, 19, 20, 21 and 22, 5 years, the animal board finds it the other way. Therefore, there is a sea change. From that time, because it's the same board on which the court relies in those 3 reports of 3 districts to come down heavily on the state in 2013 and 12 or whatever. And today that report or their stand today is that 5 years, has had a sea change and that has disappeared.
One thing, now with respect to the construction of a 11.1M.
Yes.
See, with a view to providing entertainment,
yes.
Then 1 and 2 are there.
Yes. Sir.
So unless those prohibited acts under 1 and 2 are not done, the mere providing entertainment will not be a punishable thing. Is it
grateful?
Grateful.
Therefore, I am saying that if Jallikattu,
that is the contention.
That's the contention. If Jallikattu is properly done in the form of those traditions which they had, with strict the supervision of the collector, I'll show to your lordship how it is done. It is not done in that. There is a very, very heavy supervision. I'll show you how it is done. Apart from the rules, what is the actual groundwork? Therefore, when that is done, and Jallikattu, can be done by an animal, I mean, anatomically, if I may say so. Then, even if it is for amusement, rather than a tradition, the judgment proceeds on the basis that pure amusement, you are doing something and that is bad, but that, is permitted under the law. That was the only purpose of showing this. Now, 2, 3 passages of the. I'm sorry.
One moment.
My apologies.
No, that's nothing to apologize. You have projected it on the basis of the duties of the keepers under Section 3.
Yeah.
Now, you say that animals have no right. So, therefore, no enforceable thing, obviously.
Yes.
That's what you are trying to say. Yes. Now, suppose somebody sees a particular animal being ill-treated by the keeper.
Right.
Can somebody not come and say that this animal is being ill-treated?
We can, and therefore.
Can we not therefore say that people who are before the court are actually saying that those who are supposed to keep the animals
are not keeping properly.
Not keeping properly.
Therefore, yes,
not be a.
The lordship is right, but the answer would be to punish them for the offense. No, that's when go and file a complaint. Look, this man is not my neighbor, and this is what he's doing.
No, that's okay. Punishment, yes. But then doors of the court or the mitigation forum is available.
No, my lord, it will not be available. Otherwise, my lord, see how difficult will it become. One of the clauses, my lord, says, my lord, H, being the owner of an animal fails to provide animal with sufficient food, drink or shelter. How is it enforceable? What does shelter mean? What does drink mean? What does sufficient food mean? My lord, it's impossible. Therefore, in a given case, if somebody finds that an animal is being starved, he can go to a court and say he's starved, punish him. That's it.
But to that extent, the person can come. After all, what is he projecting? He's not seeking.
For punishment, yes, my lord.
Yes, punishment, yes. Punishment, yes.
That's it. That's it. Cannot go forward to say these are statutory rights. Statutory rights will give duties. Duties will give 51A. 51A will give 5 freedoms. That's how the amalgam is grown.
He will not put it on that.
Right.
That punish him. So on the pain of punishment,
yes, your lordship is right.
Food will be provided.
I have no quarrel with that proposition. Your lordship is right. Now, my lord, see a few passages how the judgment, my lord, builds up this base of intermingling and this and that. My lord, your lordship will find. Go straight now. One. My lord, your lordship will find. My lord, I will go straight to. See, my lord, para 64. Before para 64, one thing I want to say. You'll just see 64, then I'll come back to one more parameter which I am missing. Come to 64 for a second. See another judgment. 64. See, my lord, freedom. Lord, 64 says guidelines of the World Health Organization of Animal Health, which is in 63. Yeah. Kindly turn to below page 593.
Paragraph 64.
Para 63 and 60.
Yeah.
Below 63 talks about World Health Organization of Animal Health, OIE, of India, of which India is a member, acts as the international reference organization of animal health. Now let's come to freedom. I'm straight away going to freedom. Chapter so and so recognizes 5 freedoms. Freedom not for animals, like freedom from hunger, threat, freedom from fear, distress, physical, thermal discomfort, freedom from pain, freedom to express normal pattern, etc. Now these 5 freedoms are now judicially imported into 3 and 11. Your lordship may see straight away. I'll pause here for a minute and go show to your lordship the direction. Kindly, my lord, have a look at the directions at page 601. See, my lord, for this purpose, 91.2. This is relatable to para 64. Kindly note that, my lord. Kindly note, my lord. Para 64 is relatable to direction 91.2. We declare that the 5 freedoms, sorry.
Yes, you.
This goes 601 million. 91.2. We declare that the 5 freedoms referred to earlier be read into 3 and 11 to be protected and safeguarded by the government. So a mandamus is issued by my lord reading these 5 freedoms for no real rhyme or reason into 3 and 11. 3 and 11, my lord, are not being declared unconstitutional, so that you have to read into something, you have to read down something, you have to abhor something. None of those clauses. Now, my lord, your lordship may now see 66. 66. Rights guaranteed to animals. Please, my lord, I'll read it slowly. 66. Rights guaranteed to animals. Lord Justice Ravi Kumar help me with 593. Rights guaranteed to animals under sections 3 and 11 are only statutory rights. I want to pause here for a minute. According to me, no rights are granted under 3 and 11. It's only an injunction on humans. And as my Lord Justice Zola put it, on the pain of an offense. That's it. This, my lord, is now read. See the next line. The same has to be elevated to the status of fundamental rights. Now, this country is struggling for enforcement of fundamental rights of individuals. When we come in 32, your lordship says, go to the High Court. And we are struggling, people are struggling in this country, my lord. 32 itself is a fundamental right, but you say go to the High Court or wherever. Now, my lord, if you elevate this to fundamental rights, what is going to happen? Was it ever contemplated by the Constitution? So, my lord, the next line. Rights and freedoms read with 3 and 11 are read along with 51A, G and H, which is fundamental duties. So first you put in 5 freedoms, then you put in, my lord, the Constitution, and then you create, my lord, 3 and 11 as rights. With respect, each one of those steps is wrong. And therefore, my lord, last line, it says 51A, G and H is the Magna Carta of animal rights. So where do we get animal rights in 51A?
Mr. Rodri, whenever we have a duty, there is corresponding right.
In humans.
So the structure of duties
That is also not
with rights.
my lord, that is also but that is also not absolute. Duties are there in 51, my lord. There is the right to enforce. So it is not, my lord, it's not, my lord, A is equal to B and B is C, therefore A is C. It's not one of those.
No, there is a difference because 51A right or duties,
Yeah.
they are not coupled with punishment in default.
Okay.
Whereas these duties carry a sanction that
Because they carry a sanction, so sanction will be applied. No problem. Sanction will be applied on the human because it is being made by humans. It will apply to humans.
then what is really a difference between suppose you call this the right not to be maltreated.
Yes.
Why should it
No,
not?
no, there is no right to be maltreated. Put it another
not
way.
to be, right not to be maltreated.
No, but it would not be a correct phrase. The phrase would be that the human being has no right to treat somebody. That's it. It is not a right vested in somebody else. Right? Because of this, it follows that I should not be maltreated. That's the error of the judgment. The judgment proceeds on the basis that if this is the duty on humans upon sanction of an offense, it automatically means that there is a right in the animal. And that right is intermingled with 5 freedoms and then intermingled with 51A. None of that, with respect, is a part of our jurisprudence. One more passage I left. Last lines of 64. With great respect, I should have read it. Last lines of para 64. They're very critical of those 5 freedoms. These 5 placidum D, page 593.
Yeah.
These 5 freedoms, as indicated, are considered to be the fundamental principles of animal welfare, and we can say that these freedoms find
That is at least right.
Sorry.
There are treatment.
May request for 15 minutes, not more.
There are repeated respondents, blood.
Yes.
Repetitions. Grateful, man. Grateful.